Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. I'm your host, Melanie Little. Today is Friday, February 6, 2026, and welcome to episode 5 of To Kill a Mockingbird, modern day version. Somebody needs to call Jordan Peele or Ryan Murphy, because what we are watching unfold in Athens, Clark County, Georgia is part horror. It's part psychological thriller. It is part train wreck. It is everything that you could imagine in your worst nightmare that could happen in a United States courtroom. And we are witnessing it firsthand. I don't know what the hell is going on. I don't know if I'm being gaslit. I don't know if I'm going crazy. But this is quite possibly the worst excuse for a court proceeding that I have ever seen. Am I alone? Jordan Peele should be writing a script on this as we speak. And if he's not, somebody needs to call him. After we did the Irish exit yesterday on the Daubert hearing of that very young woman who wanted to come in and testify about the Lugol iodine principle, I think it is, to determine or to locate vaginal epithelial cells. I think that's what it was about, because I was so outraged by it that I sort of lost track. This will be the first time ever in a United States courtroom that an expert has been permitted to testify in court on this particular methodology and science. The first time ever. What are we doing here? And she's going to testify today. They did another Daubert hearing this morning on some other hair analysis testimony that this expert now wants to testify that the Caucasian hairs found because of microscopic hair analysis. She's no expert. She is no expert. I mean, if you watch the Karen Reed trial with me, trial 2 specifically, the Daubert hearings that the defense experts had to go through, and these were women with more than 40 years experience in the field. And the ARCA witnesses, oh yes, they admitted her. She admitted her as an expert. She's going to testify today. She's going to testify today because that's where we are. I would go back and play the judge's ruling for you, but it seems like she had her mind made up already. It seems like it was already written out in front of her and she just read from it. And she did the same thing this morning. But this new hair analysis expert wants to say that based on his microscopic hair analysis, I didn't listen to the whole entire thing very carefully, that the Caucasian hairs found in her hands were her own hairs. And even though our friend, Mr. Cruz, pointed out that in 96% of the cases, that analysis is wrong, according to some FBI studies and other studies, this judge, I believe, is going to let it in. So you're in for an absolute treat. I don't think we're even that far behind what's going on today. So we're going to jump right on in there. If you guys are not familiar with the case, there are extensive show notes below the video. There are very, very, very few times where I am speechless, and this is one of them. But before we do that, we have affirmations for a badass that we pull every single day. And here's the one we're going to pull today. We're going to shuffle them, and we're going to pull it. She is causing appellate issues. She absolutely is. How is she not? No, she 100% is. We're down to like not much of the deck left, but here's the one from the middle. Dear stress, F you. That's today's affirmation for a badass. It says, dear stress, F you. If you needed that in your life today, there it is. Tell your stress to F off. Edrick Faust is on trial for the 2001 murder of a young law student by the name of Tara Baker. From all accounts, she was a lovely woman. Everyone loved her. She was 23 years old, and on the evening of her 24th birthday, she was brutally murdered, raped, beaten, strangled with a cord, the cord to the printer that was in her room. The hair analyst did testify this morning that the hair from the printer does match Chris Melton, so we got that, the boyfriend. Strangled, beaten, raped, essayed, stabbed with a knife, and then her house was set on fire. 23 years later, the man who's on trial today entered the court file for the very first time when his DNA, which was in CODIS, was allegedly connected to something off of maybe an oral swab or a vaginal swab of the victim. We're not really sure because the swabs were mislabeled. Much evidence has been lost. And yet this man is on trial today with something like 12 counts. Never even appeared in the court file until 2023 or 2024 when he was arrested. So it's terrifying. Oh, that is a great word for it. It's terrifying. And welcome to Georgia. This is Athens, Clark County, Georgia. It's a mess. And we can't turn away because this man needs our help. Many people need freeing, and this man is one of them. And was he a convenient patsy? You decide. Let's get into day 5. You can let me, I think we are.
Someone else who has those same characteristics.
Okay, so that was the hair analysis Daubert hearing from this morning, which we are not going to watch right now. We could do a whole separate show on the Daubert hearings. Originally, the jury was told that it was going to be a 2-week trial, and then during pretrial, they said it could be 4 to 6 weeks. And then the judge was like, "Yeah, no, I told the jury 2, so it's going to have to be 2." So I'm not sure where they landed. I think that's why the judge is working until 6 o'clock every day. Feels like we've been here forever. This is only day 5, and I was sick on day 3. So let's get on in there.
Included on our witness just for
Looks like 20 minutes ago. Here's day 6.
Just for disclosure, I just located a witness that we had previously tried to find. He wasn't included on our witness list because I couldn't find any good information for him. But I bumped into him into the courthouse, and I'm assuming that they have an objection to it. But we're going to amend our witness list tonight. Provide state notice of his information. I just got his information, which would allow us to bring him in during our case in chief. But I do think because it's in the middle of trial and it's kind of the last minute, it's something that does need to be brought to the attention of the court, just so the court to decide if this is something the court would allow or not allow, and that would determine our preparations.
All right. Thank you, Mr. Yellowman-Shilly.
I guess one of the first questions would be, who is it? I mean, and as far as a determination for the court, what would this person testify to? I don't know that not having contact information is grounds for not including somebody on a witness list. If it's newly discovered information, that's a separate thing. But before the state takes a position, I just would need some more information as well.
All right. At this point, I'm not going to allow another witness on the witness list.
Stop.
The witness lists have been out for a long time.
Okay. I'm already going to lose my shit this morning. We've got truckers against tie clips pulled over somewhere in, I think he said Indiana. The roads are bad. He's pulled over to listen to the show. Good morning. Good morning, Mike. Fast Finance with Jennifer says, what do you think the jury's thinking and feeling at this point? Well, I'm so glad you asked, because one of our cupcakes is in the courtroom today, and her name is Christy, and she's going to be reporting back to us about what the jury is thinking, feeling, and what their makeup is. And if you have any questions for her, put them in the chat or email them to me so that I can ask her while she's there. She's not allowed to use her phone while she's in the courtroom, but she will be communicating with me. And so we will find out. Thanks, Jennifer, for asking, and thanks for tuning in from Canada. And let me know if my volume is equal with the court volume, because when I went back to listen yesterday, I was way lower than the court volume. So I just want to make sure that we're kind of even. If I need to boost court a little bit, let me know. Here he is. Here he is. Now he's changed his name again. 18-wheeled Maligator crate. Hear that audible snap? That was the 6th Amendment breaking off. Thank you to Christy. Trials, and we say this all the time, are a living, breathing thing. If new witnesses come to light during the trial, who is the one who's entitled to a fair trial? Is it the defendant? I mean, last time I checked the Constitution, the Bill of Rights, it was the defendant who was entitled to a fair trial. Not in this country, apparently. What are we doing? Let's see what her reasoning is for this one.
They have been subject to amendment. All right. At this point, I'm not going to allow another witness on the witness list. The witness lists have been out for a long time. They have been subject to amendment before we began.
You know what's been out for a long time? The closing of this case. This case is 25 years old. That's been a long time. Okay? Witnesses move in a 25-year period. That's been a long time. I'll boost it a little bit and just tell me if that's better.
In this trial, if it was somebody that either side knew that they wanted to testify, even if they couldn't find them, that person needed to be included. The jury, the entire
That's me.
Jury pool,
That's
but particularly the jury that has been seated, they were all asked questions about whether they were related by blood or by marriage to all of the witnesses in this case. And that would not have been done for this particular addition. And so I'm not going to allow it. All right. Anything else before we bring the jury in?
I just would like to get a sense of the court's.
They've all been asked if they were related by blood. Wait, what? Hold on. I'm sorry. I'm so outraged that I got to go back a little bit. I hate starting my day this way. I didn't know what was going to happen. Hold on.
Discovered information, that's a separate thing. But who is it? I mean, and as far as a determination for the court, what would this person testify to? I don't know that not having contact information is grounds for not including somebody on a witness list. If it's newly discovered information, that's a separate thing. But before the state takes a position, I just would need some more information as well.
All right. At this point, I'm not going to allow another witness on the witness list. The witness lists have been out for a long time. They have been subject to amendment before we began this trial. If it was somebody that either side knew that they wanted to testify, even if they couldn't find them, that person needed to be included. The jury, the entire jury pool, but particularly the jury that has been seated, they were all asked questions about whether they were related by blood or by marriage to all of the witnesses in this case. And that would not have been done for this particular edition. And so I'm not going to allow it.
I'm sorry, you
All right,
can't
anything
ask,
else before we?
can't ask these 15 people one more question to see if they're related by blood or marriage to this new witness? Are you flipping kidding me? You can't.
Bring the jury in.
I just would like to get a sense of the court's preference. Our next witness is going to be Ms. Licon, who testified last night.
Right.
Certain exhibits were admitted during that Dahlberg hearing last night. It would be the state's preference to just use the same exhibit number just for, and I don't know.
I mean, I think the same exhibit number is appropriate. Mr. Cruz made it very clear, unless you tell me otherwise, it was admitted for the purpose of that hearing only. So you'll go through the same process if you want to, about admission of evidence, if you want to admit those. But I think the numbers need to stay the same.
That's what I thought too, Your Honor. I just wanted to be clear before I started putting stickers on things.
Okay, very good. Thank you. All right, anything else?
And Judge, this is kind of in that same vein as it's going to relate to Mr. Peterson's testimony. The copies of his reports that I admitted during the Dahlberg hearing are not redacted. And so would the court want me to redact what's already been admitted prior to it being shown to the jury or handed to the witness? Or would you like me to leave it in its actual form as it was admitted during the Dahlberg hearing?
I'm not sure I understand what you're saying. Are there portions of the evidence that you admitted during the hearing that need to be redacted?
Yes, Judge.
Okay.
In accordance with the court's ruling on the state Saudi motion, some of the information listed as far as suspect or some of the elimination samples that aren't actually relevant to the trial of the case.
Sure. I would say this as a general rule. Mr. Cruz, you certainly can respond before I say anything about what he's referring to. Anything you'd like to add?
No, ma'am.
Okay. Thank you. So I would say, Mr. Yalamanchili, for efficiency purposes, that it would be imperative to redact what is appropriate to redact before you tender it. And I think that's the best way to handle it, as opposed to after.
Yes, Judge.
All right.
Happy to do so.
All right, very good. And you can show, obviously, Mr. Cruz, what you're redacting. If you have any objection to that, obviously we'll take it up before it gets admitted or is offered for admission. But
Thank you, Your Honor.
thank you, Mr. Cruz. Anything before the jury comes in? All right, thank you. You may bring the jury in.
He gets to play with stickers and he's real happy about it. And the defendant is not allowed to put on a case because this judge has her head up her ass. Welcome, Dinderloo. I hope you're going to like it here. Thanks for becoming a member. Karen says, I wrote Mr. Cruz last night to encourage him to watch you. I live 30 minutes from UGA and my daughter went there. I may try to go watch next week. I need to know the other cupcake. Well, if I don't know how many days Christy's going to be there, but she did speak to him this morning apparently and did tell him that he's got an army behind him in you guys. So thanks, Christy, for being there and for letting him know that. And Karen, if you do go, reach out, send me an email and let me know what day you're going to be there. Thank you for your super chat.
Everyone may be seated. Thank you. Good morning, ladies and gentlemen. We are back here in court today with regard to State of Georgia versus Edrick Faust, SU 24 CR 0547. I appreciate you all arriving here on time as usual. I just want to let you all know that we are starting late today, and I promised you that we would be as efficient as we could, and we are actually keeping to that promise. It may not seem like it because we're starting late. I just want to explain to all of you. We were here late last night, handling some matters, of course, that needed to be done outside your presence. The attorneys were here really late. We knew we needed to be here today, to handle some other matters outside your presence. I didn't have it in my heart to make them come in at 8 o'clock because it was a long day yesterday and we were here really late. So we got here at 8:30 and started right away. And obviously we weren't finished until now. So I just want you to know we're not wasting your time. And chatting about things that, you know, we don't need to be chatting about. I just want you to know we've been working very hard to get through some things so we can get started. I appreciate you all filling out the lunch menus. Of course, we're doing that again today because we have an early day today, and I just want to get through things as much as we, you know, as much as we can. On Monday, we'll go back to kind of a regular schedule, and we'll have a regular lunch hour. You all can leave and stretch your legs and get some fresh air and things of that nature. And so I just wanted to make sure you're aware of that. All right, we're going to get started. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right, thank you. You may call your next witness.
Marissa Licon.
Could you get Marissa Licon, please?
They couldn't even, I bet you they couldn't even place odds on this trial in Vegas because it's about as obvious as professional wrestling. Like you couldn't even put a line on this because it's obvious 100% of the time the prosecution's going to win. They don't even need to argue. We need Ed Wallace on this.
Please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I mean, no shade against her. She has testified as an expert once. Once. She's literally maybe 12 years old. Maybe 18 with the hair flip. Come on. What are we doing? I've got my magic 8-ball here because that's about the way that the judge is deciding these motions.
Can you please state your name and spell it for the court reporter?
Marissa Licon, and it's spelled M-A-R-I-S-S-A. Last name is L-I-C-O-N.
Ma'am, how are you employed?
I'm employed at Pure Gold Forensics.
How long have you been employed at Pure Gold Forensics?
Since May of 2022, so approximately 3.5 years.
And tell us a little bit about Pure Gold Forensics. What is it?
We're a private accredited forensic DNA testing lab located in Southern California.
What kind of testing does Pure Gold do? Generally speaking.
So we do serology as well as DNA testing for prosecution, defense, as well as private parties.
What is your position at Pure Gold Forensics?
I'm a forensic scientist.
Can you please
She was a lab assistant 2 years ago.
explain what your job entails?
So it involves serology testing as well as DNA testing using Global Filer as well as Y-Filer amplification kits. I analyze mixtures using StarMix probabilistic genotyping software, interpret the data, and producing a scientific report based on the data.
Can you talk a little bit about your educational background?
I have a bachelor's of science degree in forensic chemistry with a concentration in criminalistics.
And other than the education,
When did you graduate? When did you graduate from college, ma'am? I'm not shading her. I love girls in STEM. But if you are going to testify in a murder case that the world is watching now, you need to be qualified as an expert under Daubert to testify to such matters. Not to mention, this is the first time in the history of the United States of America that an expert of this type has ever been admitted to testify to this particular subject in a court of law. And there's a reason for that.
that you received in obtaining that degree, is there any other training or experience that you have that has assisted you in your work as a forensic scientist?
Yes, so upon being hired at the lab, I underwent their training program. So it was approximately 1.5 years total. I was first trained in serology, which is the identification of body fluids. I underwent an observation period in which I watched another analyst perform the testing, a practical period in which I performed the testing on mock samples. I completed a oral as well as a written exam, and then completed and passed a competency test. I was observed on 3 cases before I was signed off to do independent casework in August of 2022. Subsequently, I was trained in DNA analysis, in which I also underwent an observation period, a practical period, where I performed testing on mock samples using different extraction methods. I completed my own sensitivity as well as mixture studies. I completed and passed 2 competency tests, as well as 2 moot courts, and completed an external 4-day STAR mix training.
And ma'am, are you?
We're talking about moot court, okay? This is her resume. She's passed 2 moot courts. I mean, in 2022, she started like watching other people do it, and she watched other people do it like 3 times, and then she was certified to do it. Is this a joke? Are we all in on the same joke here? My sound is low versus the court. All right, I'm gonna unboost the court. So now
You a member of any professional organizations?
that's the court, and now that's me. So right, it doesn't need a booster. Now we're okay because now they have microphones. All right, thank you for telling me. We had a citizen investigator. She observed some testing 3 times, and now I don't even know what to say to you guys anymore at this point. I don't know. Is it me? Maybe it's me. I don't like this joke either. Did she stay at a Holiday Inn last night? Here we go. They were like, "Oh, we'll just give her up to the wolves. She's never going to be admitted as an expert, but they paid, so let's just send her." Here we go.
Where I performed testing on mock samples using different extraction methods. I completed my own sensitivity as well as mixture studies. I completed and passed 2 competency tests, as well as 2 moot courts, and completed an external 4-day STAR mix training.
And ma'am, are you a member of any professional organizations?
Yes, I'm an affiliate member of California Association of Criminalists, as well as a professional affiliate member of American Academy of Forensic Sciences.
And ma'am, outside of this case, prior to coming to Athens, have you ever testified as an expert in court before?
Once,
Once,
And where was that?
in Colorado,
one
And
time.
what was the nature of that testimony?
DNA testing.
Your Honor, at this time, the state would ask that Ms. Licon be permitted to testify as an expert in forensic chemistry and forensic biology.
Any objection from the defense?
Yes.
Based on another court's prior ruling.
Well,
This-
he can't because she already ruled on it during an extensive Daubert hearing yesterday that went until about 6:30 p.m. Yes, Your Honor, I object. This is a travesty of justice. This is a joke, and we're all in on the same joke, right, Judge?
Witness is declared an expert in the areas of forensic chemistry and forensic biology. You may proceed.
Thank you, Your Honor. Ma'am, back in 2020,
The one time that she testified, she was deemed an expert in DNA testing, not forensic chemistry and forensic biology. Seems like there are a lot of grounds for appeal already. Let's hope to God there's no conviction here, because if there's a conviction here, I don't even know. I don't even know what I'm gonna do. I may start to cover entertainment or something. I may start pop culture coverage because I can't handle this anymore. If he gets convicted, I just can't do this anymore. We'll see. Half joking.
24 was Pure Gold Forensics asked to perform certain serology testing on 2 items of evidence submitted from the GBI crime lab.
Yes.
What items did you receive from the GBI?
We received 2 items, which were apparent cuttings of swabs.
How were those items submitted to your lab?
We received them via FedEx.
As opposed to carrier pigeon, donkey, cannonball. Are we being punked? Ashton Kutcher is going to jump out of the corner of the courtroom any minute. This is going to be like jury duty. Oh, who's playing this joke on me? This trial is only visible to me on YouTube, right? And you guys. This is like that show Jury Duty from Amazon Prime. It's all a big joke, right? It has to be. This can't be real life. This can't be real life. I'm sorry. Did you lose your script?
Okay.
I'm going to hand you an item that's been labeled, I believe, States 141. Is that right?
Correct.
Okay. And what is States 141?
It's the envelope we received.
And how do you recognize that envelope, ma'am?
This is the envelope I opened and tested the items inside.
And does your initials appear on that item?
Yes.
In what condition was States 141 when you received it at Pure Gold Forensics? Was it sealed? Let me ask.
Yes, it was sealed.
I'd move to tender States 141, Your Honor.
Any objection, Mr. Cruz? It is admitted.
Ms. Licon, inside States 141, are there a number of items in there?
Yes.
Okay. Can you take those out? Okay. States 142, what is that?
This is Georgia Bureau of Investigation, their evidence transfer receipt.
Was that, again, located inside States 141 when you received it at Pure Gold?
Yes.
And in fact, as going back to States 141, was that item completely sealed until just a few minutes ago right outside of court?
Yes.
And did you witness it being opened prior to coming in and testifying?
Yes.
Okay.
Oh, did you want her
States
to?
142, what is that?
Did you make sure to open it in the hallway in front of her to make sure there was actually something in the envelope? Oh, well done to you, Chris with a K Bolton.
That's the transfer receipt.
Oh, I'm sorry, 143. Pardon me.
This is an envelope labeled cuttings of item 2I, oral swabbings B.
And 144, what is that?
Some were oral, some were vaginal.
A
They're
sealed envelope
mislabeled.
labeled cuttings of item 2J, oral swabbings A.
And just again to clarify, when you received States 141, were 142, 143, and 144 all contained inside of it?
Yes.
Do you recognize, especially as it relates to 143 and 144, those items as having your initials on them?
Yes.
At this time, I'd move to tender States 142, 43, and 44.
Any objection, Mr. Cruz?
That's what.
No, Your Honor.
They are admitted. You may.
I heard that there have been some protesters out there, Susan Smith. That's what Christy told me that Mr. Cruz told her this morning. Although she said she didn't see them when she was coming in because she got to court real early. Because that's the way the cupcakes do it. There's extensive show notes below the video if you're not familiar with the case. Thank you, Susan, for gifting 5 memberships. You're so
Ms.
sweet.
Khan, based on the request, as you might have understood it from the GBI Crime Lab, what, if any, tests did you believe may be relevant in making any determination as to the potential biological source of the items of evidence that were contained in States 143 and 144?
We were requested to perform saliva testing as well as vaginal epithelial cell testing. So I determined that our RSID saliva test, as well as our Lugol's iodine test, presumptive for vaginal epithelial cells, were appropriate.
Let's start with the RSID saliva test that you just described. Briefly, ma'am, what is amylase?
It's an enzyme found in saliva.
Okay. And where is amylase primarily found in the human body?
In the mouth, saliva.
How does the RSID saliva test test for the presence of amylase in a biological sample?
So it's a lateral flow test strip. So essentially you have your sample that's been extracted and you combine it with a buffer that comes with the test kit, and then you deposit that onto a cassette that has a membrane that contains antibodies that are specific for the antigen, which in this case is the alpha amylase from saliva. And when you deposit your sample, if the alpha amylase is present, the antibodies will capture it, and it'll continue down the membrane. And a positive test will result in 2 visible lines, and a negative test will result in a singular line.
Does it kind of resemble like a COVID test?
Yes, or like an at-home pregnancy test.
What does RSID stand for?
Rapid stain identification.
Oh, you mentioned that. I just want to be clear. Has the RSID saliva test been validated as an appropriate test for detecting the presence of saliva at Pure Gold Forensics?
Yes, we complete our own internal validation.
And has Pure Gold Forensics tested for the sensitivity of the RSID saliva test?
Yes, so during our validation, we tested different dilutions of saliva, and we came to the conclusion that the RSID saliva test kit can detect as little as 10 nanoliters of saliva, and so there's 1 million nanoliters in 1 milliliter.
So that a significantly small amount of
Yes.
sample. Okay. Can the RSID saliva test yield false positive results?
There are other biological fluids that can yield false positives, such as human breast milk, fecal matter, and high concentrations of sweat.
If there are any forensic experts in the chat, and I know that we've got the smartest chat on the internet, and you are a professional, let's try and help Mr. Cruz with your expertise and call BS on what she's saying and why. He needs all the help he can get at this point.
And when we say false positive, just to be clear, what exactly does that mean?
Another substance that can give a positive test, but it's not the specific substance you're testing for.
And based on the possibility of a false positive result, is the RSID saliva test only considered a presumptive test rather than a confirmatory test for the presence of saliva?
Yes.
And can you just kind of explain for the jury what we mean by presumptive test versus confirmatory test?
So a presumptive test gives the likely presence of a substance, but due to false positives, it's not a definitive yes or no, whereas a confirmatory test is highly specific and can give a definitive yes or no, this substance is present.
Ma'am, to your knowledge, is there a confirmatory test regarding whether or not a sample of biological evidence is positive for the presence of saliva?
No.
And is the RSID saliva test generally accepted in the scientific community as a presumptive test for the presence of saliva?
Yes.
I want to shift gears a little bit and talk about Lugol iodine. What is the Lugol iodine test designed to look for?
It's designed to look for glycogen.
Before we get into glycogen, let's talk a little bit about epithelial cells. What is an epithelial cell?
It's a skin cell.
Okay. And can epithelial cells come from all over the human body?
Yes.
Can you please describe, generally speaking, the science behind the Lugol iodine test?
Yeah. So the premise behind the test is that the glycogen content.
Pay attention, because this is the first time in the history of the United States of As Such America that the Lugol iodine test is being allowed into a United States courtroom to convict a defendant of any crime, but in this particular case, several charges of murder.
A vaginal epithelial.
Generally speaking, the science behind the Lugol iodine test?
Yeah. So the premise behind the test is that the glycogen content of vaginal epithelial cells is extremely high between a woman's first menstruation and menopause. So when these cells are stained with the Lugol's iodine, they'll exhibit a dark chocolate brown color. There are other areas of the body that do contain glycogenated cells, such as oral secretions, as well as the urethral opening of the penis. However, the glycogen content of these areas is less abundant. So based on our validation as well as studies, we use a 10% threshold that if more than 10% of the cells stain the dark chocolate brown color, it's considered a positive indication for vaginal epithelial cells.
And ma'am, I think you might have hinted at this just now, but can you explain a little bit about why the Lugol iodine test might yield different results on a sample collected from a vaginal swab versus a sample collected from an oral swab?
Yeah, so amylase that was mentioned earlier that's present in saliva breaks down glycogen. So that's why there's a less abundant amount of glycogen in oral secretions.
And again, I think you might have answered this a minute ago as well, but is there a generally accepted percentage of chocolate stained cells that one might observe which would indicate that a sample was collected from a vaginal swab?
Yes, we use a 10%.
And is that percentage higher or lower than others may have accounted for?
Yeah, so there's a study that examined buccal cells versus vaginal epithelial cells. And they determined that with a water extraction and mechanical shaking of the sample, actually less than 1% of oral secretions will stain the chocolate brown color. So our 10% threshold is more conservative.
Is the Lugol iodine test validated by Pure Gold Forensics as a presumptive test for the presence of vaginal epithelial cells?
Yes.
And to your knowledge, is there such thing as a confirmatory test for the presence of vaginal epithelial cells?
No.
Let's hear that again.
So our 10% threshold is more conservative.
Is the Lugol iodine test validated by Pure Gold Forensics as a presumptive test for the presence of vaginal epithelial cells?
Yes.
And to your knowledge, is there such thing as a confirmatory test for the presence of vaginal epithelial cells?
No.
So there's no confirmatory test for the presence of saliva, and there's no confirmatory test for the evidence of vaginal epithelial cells. And yet we should let the jury hear all about this, because in this judge's words and in the Daubert standard, it is going to help the jury understand the issues more clearly in this murder case. Are you picking up what I'm laying down here? Because when you allow an expert to testify about something, the impression to the jury is that this person knows what they're talking about and that they are an expert in the field and that their opinions can be trusted. And what she has just said is the furthest thing from it. This is junk science at this point. That is why no other judge in the country has ever allowed this in to any trial ever. And they're probably lost. You're right.
Man, when you received what we've tendered into evidence as states 143 and 144, these are the samples of cuttings, is that right?
Yes.
Please describe the process by which you undertook the testing that you performed.
So I first reviewed the case file, and then I removed the evidence from our evidence storage, took it into the evidence examination room where I opened it, took photos, took notes of it, and then I took it for our extraction procedure. It's our analytical procedure 5, which is a general extraction procedure that allows the analyst to retain the substrate, take the liquid portion for serology testing, and then take the cell pellet portion for either DNA extraction or microscopic examination.
Okay. And once you did all that, did you perform both the RSID saliva test and the Lugol iodine test on each item?
Yes, I did.
Okay. And just to be clear, when we're talking about the Lugol iodine test, how are you looking for or observing those chocolate stained cells that you just described earlier?
The process of putting them on the slide.
Yes.
So it goes back to the extraction procedure. So I take the substrates, which in this case were the apparent cuttings of swabs, and I place them into a test tube along with sterile water. We allow it to incubate for approximately 30 to 60 minutes. And during that time period, we vortex it several times, which means to shake vigorously. We do that by putting it on a machine. When that time period has passed, we centrifuge, we take the substrate.
Shake it vigorously, you know, like you do in the morning with your shaker cup when you're making your protein shake or your protein water. You just shake it vigorously.
We put it into a spin basket on top of the same tube, and then we centrifuge the tube extremely fast so it spins fast, which pulls the liquid from the substrate. At this same time, it causes the cells within the sample to pellet at the bottom of the tube. So when that's done, we remove the spin basket, place it into a separate tube, and then left in the tube, we have the liquid portion as well as the cell pellet. We pull off the majority of the liquid portion and then place that into a separate tube. That's what we refer to as the supernatant, which can be used for the different serology tests, so body fluid identification. And then left in the original tube, we have the cell pellet along with a small amount of liquid. So to get to the microscopic exam part, we vortex the cell pellet along with the liquid, and then we take a small amount, so 2 to 10 microliters, and we place it onto a slide, heat fix it, and then we stain it with the Lugol's iodine.
Thank you. And again, I want to talk about the testing results specifically related to states 143, which is your item number 1, labeled as cuttings of item 2I, oral swabbings B. That's super confusing. As it relates to this particular piece of evidence, regarding the RSID saliva test, what was your result?
It was positive for RSID saliva.
I'm just going to.
Scope of the Honorable Court's ruling in regards to Dauber yesterday, if I'm not mistaken.
Hold on one second. I want to hear her that question and answer one more time.
As it relates to this particular piece of evidence,
Which one?
regarding the RSID saliva test, what was your result?
Okay, wait, hold on.
It was positive for
Here.
RSID saliva.
Evidence labeled as 3, which is your item number 1, labeled as cuttings of item 2I, oral swabbings B. That's super confusing.
Yeah.
As it relates to this particular piece of evidence.
Yeah, sure. Just hold up the particular piece of evidence and expect the record to be clear, because this is the only evidence that you have that points to the defendant ever coming into contact with the victim. So make sure that it is clear as mud. This is supposed to help the jury, and 2 additional sketches of other suspects were not admitted into evidence by this judge because she said it would confuse the jury. Remember that. I still don't know which swab he's talking about, so I'm going to take it back a little bit further.
To get to the microscopic exam part, we vortex the cell pellet along with the liquid, and then we take a small amount, so 2 to 10 microliters, and we place it onto a slide, heat fix it, and then we stain it with the Lugol's iodine.
Thank you. And again, I want to talk about the testing results specifically related to states 143,
140,
which is your item number 1.
143. Okay, so
labeled
this is states
as
143.
Cuttings of item 2I, oral swabbings B. That's super confusing.
Oral
as it
swabbing.
relates to
B,
this particular piece of
positive for
evidence,
saliva, right?
regarding the RSID saliva test, what was your result?
It was positive for RSID saliva.
Okay.
Objection, I believe that exceeds the scope of the honorable court's ruling in regards to Dauber yesterday, if I'm not mistaken.
He says it's outside the scope of the judge's ruling yesterday on Daubert.
I believe that testimony that we just received exceeded the scope of the testimony expected from the Dauber.
Mr. Bolden, any response?
I mean, the fact that it's positive, I think the witness has established that that's not a confirmatory test, it's just a presumptive test.
Yeah. If that's in the form of an objection, I'm going to overrule the objection.
Of course.
Go ahead.
Because there is no confirmatory test for saliva.
If I can approach, Your Honor?
You may.
And I'm going to show you what's been marked as States 145. Do you recognize that?
Yes.
What is States 145?
It's the RSID saliva cassette testing results from our item number 1.
Okay. And does that picture fairly and accurately depict the results of the test on the cassette?
Yes.
Contender States 145, Your Honor?
Any objection?
No, ma'am.
It is admitted.
He's like, what's the point of objecting? This is
Does the pure gold actually retain the cassette itself?
No, as long as we take a photo of it, we throw it away after.
you wait, you throw away the sample? wait, what? Wait, what? As long as we take a picture. Wait, is that can't be what she just said. Hold on a second. That can't be what she just said. I'm sorry, I must be wrong.
Does the pure gold actually retain the cassette itself?
No, as long as we take a
Do you retain the cassette itself? The cassette. Where are my forensics experts? This is a cassette of some sort. Hold on.
And I'm going to show you what's been marked as States 145. Do you recognize that?
Yes.
What is States 145?
It's the RSID saliva cassette testing results from our item number 1.
Okay. And does that picture fairly and accurately depict?
What is a cassette testing for results? Number 1, the test. So they just take a picture. So if I'm understanding correctly, it's like a pregnancy test where like a line shows up and they just take a picture of it and then they throw it away. My head's going to pop off.
The results of the test on the cassette?
Yes.
Contender States 145, Your Honor?
Any objection?
No, ma'am.
It is admitted.
And does the pure gold actually retain the cassette itself?
No, as long as we take a photo of it, we throw it away after.
I mean, is that the way it's supposed to be? I'm not a scientist. I'm not a forensic expert. Is that what's normally done? Is you just throw it away, the results, because the pictures don't lie? Do we have metadata on the pictures? How do we know that's even? I don't know what to say.
With regard to the Lugol iodine test,
Maybe that's
on
normal.
States 143, what were your results on that, ma'am?
It was negative for the presumptive presence of vaginal epithelial cells.
Okay. And did you take a photograph of the microscopic slide that led you to that conclusion?
Yes.
If I can approach again, Your Honor.
You may.
Maybe because, once it sits around for a long time, then it changes color. Maybe that's it. I don't know.
This is States 134. Do you recognize that?
Yes.
What is States 134?
A field of view from the microscope slide from our item number 1.
Is that a fair and accurate depiction of the slide as you observed it when you conducted the Lugol iodine test on that piece of evidence?
Yes.
Move to tender states 134.
Any objection?
No, ma'am.
It is admitted.
Your Honor, if I could publish 145 and 134 to the jury at this time?
Are you going to do it on the machine?
Yes, ma'am.
It is on.
Thank you. All right, we're going to start with
Excuse me,
states
bro.
145. Ms. Licon, again, what is this?
This is RSID Saliva cassette testing results from our item number 1.
You indicated that that was positive test.
Yes, it's positive
And how do we know that?
with the visible 2 lines.
States 134, again, is that the picture of the microscopic slide after performing the Lugol iodine test on states 143?
Yes.
Okay. What are we seeing here?
We're seeing yellow staining. So epithelial cells that are not glycogenated will exhibit a yellow or no staining.
And so again, with the Lugol iodine tests, what was the result of that, if I didn't ask?
It was negative for the indication of vaginal epithelial cells.
All right, we're going to shift gears now to states 144. With regard to this piece of evidence, again, just to be clear, did you perform both the RSID saliva test and the Lugol iodine test on the cuttings from this item, ma'am?
Yes, I did.
Okay. And as it relates to the RSID saliva test, what was your result?
It was a negative RSID saliva test. No indications of saliva were detected.
If I can approach Your Honor.
You may.
On this is states 146. Do you recognize that?
Yes.
Is that a fair and accurate portrayal of the cassette in which you performed the RSID saliva test on states 144?
Yes.
I move to tender states 146 at this time.
Any objection?
Okay.
It is admitted.
And did you also perform the Lugol iodine test on states 144?
Yes.
And what was the result of that test?
Greater than 10% of the cells stained the chocolate brown color, so the indication of vaginal epithelial cells were indicated.
And like before, did you take a picture of the slide with which you made that determination?
Yes, I did.
If I can approach one more time.
You may.
This is states 135. You recognize that?
Yes.
44 says, I wouldn't hire this defense attorney for a DUI. Well, it's a good thing you're in Ireland and you don't have to worry about that, isn't it?
Is that a true and accurate depiction of the slide that you created and observed after running the Lugol iodine test on states 144?
Yes.
Any objection? It is admitted.
And if I could publish these to the jury.
You may.
All right, this is 146. Again, is that just, oh, that's upside down. Is that the RSID saliva cassette that you used in examining states 144?
Yes.
And it just, again, to be clear, what was the indication on that test?
The
Positive or negative?
negative.
And how are we seeing that here?
There's only a singular line at the control line and not a line at the test line.
But that was an
It's
oral swabbing, correct?
135. And again, just to be clear, is this the picture of the microscopic slide after running the Lugol iodine tests on states 144?
Yes.
And what are we seeing here?
We're seeing greater than 10% of the cells have exhibited a chocolate brown staining. So that's why it was considered a positive indication.
It's confusing the jury.
Based
Tell me if you think
on
he's confusing
your
the
training
jury.
and experience, coupled with the results of the testing that you performed on states 143, which is GBI item 2I, that testing to include both the RSID saliva test and the Lugol iodine test. If I were to tell you that that sample came from an oral swab, would that be consistent with your findings?
Yes.
As it relates to
Right.
states 144, your item number 2, GBI item 2J, again, based on your training and experience, coupled with the results of the testing that you performed on this piece of evidence to include both RSID saliva and Lugol iodine, if I were to tell you that this sample came from a vaginal swab, would that be consistent with your findings?
Yes.
Here's the problem.
And
What is all of this
lastly,
proving? All of this is proving that these were all labeled oral swabs, but her testing showed that one of them was actually a vaginal swab and not an oral swab. And this is the only evidence that they have allegedly connecting this defendant to this victim in any way, shape, or form. Hopefully the defense is going to be able to tie it all together in a way that the jury can understand it.
In connection with all the testing that you've described here this morning and the slides and cassettes that we've all gone over, did you have an opportunity to prepare a report that summarized those findings?
Yes.
Reports are not supposed to be allowed into evidence.
Back in approach, Ron.
You may.
All right, this has been marked states 133. Is that just a copy of the report?
Why do you need to show her her report?
Yes.
I move to tender states 133.
Any objection?
Hearsay.
Yeah.
Any response to the objection of hearsay?
No, Your Honor.
It is overruled and admitted with your objection.
Ma'am, those are all the questions that I have for you. The defense counsel may have some questions.
Mr. Cruz? Yes, go ahead, sir. All right, cross-examination, Mr. Cruz.
Ms. Lycon, good morning. My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Edrick Faust. We previously had opportunity to speak yesterday. Is that correct?
Correct.
Okay. And would you tell the jury, is it true that you would agree that you're from California? Is that right?
Yes.
Okay. And the state of Georgia brought you here from California to testify about the testing that you conducted in this case. Is that correct?
Correct.
Okay. And if you know, other laboratories in the United States conduct RSID saliva testing. Is that right?
Yes.
Okay. And even some laboratories in Georgia. Is that correct?
I don't know.
That's fair. Other labs also conduct the Lugol's iodine test. Is that correct?
Correct.
Now I want to ask you this. You've been doing this since 2022. Is that fair?
Yes.
But you have never been asked to come into court and testify to the Lugol's iodine test. Is that right?
Correct.
And I think we agree on this. So this is your first time being asked to testify on these presumptive tests.
Correct.
How about the RSID test?
Is this my first time?
Correct.
Yes.
Okay. So no other state has said, hey, can you come testify about these presumptive tests to a jury?
Correct.
And neither are confirmatory tests. I think, excuse me, there aren't any confirmatory tests for these two tests. Is that right?
Correct.
Now, I want to ask you this. You were given some packages that involve swabs. Do you still have those up there with you?
I don't.
I'm going to give you a pair of gloves.
Okay.
Yes, the jury is there. Yesterday, she testified in a Daubert hearing in which the jury was not there. So if you think you heard this yesterday because you watched it with me a little bit and then by yourself for the rest of it, you did, but the jury was not there. They are there today because the judge agreed to let her
Let the
testimony
record
in
reflect that I've given Ms. Licon a pair of gloves.
and qualified her as an expert.
I've given her State's Exhibit 141. I am also going to give her State's Exhibit 142 and a pair of scissors. All right, Ms. Licon, can you open the two packages that you have?
I am going to object to the relevance of having this witness open that package, especially in light of what happened yesterday.
Mr. Cruz?
Sure. The state introduced those items as exhibits. I believe we expressed on the court before that it's the items that's inside that is relevant. We just want to see the items that's inside, so I can ask her some questions about that.
Yesterday,
Take
somebody
I'm going to take a step outside the presence of the jury, and we are going to have a restroom break. So if you'll go in.
Yesterday, somebody dropped some slides on the floor. I think it was the defense attorney, but I'm not even sure. But the reason the prosecutor doesn't want this to happen is because in one of the early days of the trial, maybe day 1 or 2, the witness was asked to open up the envelopes that contained the hairs that were found on the victim. And when the witness opened all 3 envelopes, the hairs were not there. The envelopes were empty.
Into the jury room. This will be a restroom break. Mr. Cruz, I'll certainly give you one as well.
Thank
Please don't discuss the case. If you'd like to do that first and come back,
Okay.
that'd be fine.
Thank you, Your
Go
Honor.
ahead, sir.
Of course, it's relevant. Like, this is just mind-numbing.
I mean,
State about the objection again. Now that we're outside the presence of the jury, anything further from the state about the objection?
no, it's just a relevance objection, Your Honor.
Like-
I mean, Ms. Licon testified.
It's like a relevance objection, Your Honor. You know, like our case really, really blows. And like, the more you let the jury see that there's no evidence inside the envelopes, like, how are we ever going to rig this anymore so that we can win, Your Honor? Like, oh my God. Boss baby emoji has now been officially reassigned to this guy, Chris Melton. Okay? And the binky emoji, feel free to use it. Like, Your Honor, I'm sorry. I'm gonna stop talking for a little while.
No, it's just a relevance objection, Your Honor. I mean, Ms. Licon testified that she received those items sealed and then, open them to conduct the testing that she described. I apologize. I have a lifesaver in my mouth. I didn't know we were going back on the record so quickly.
Oh yeah, you didn't know that you might choke on your lifesaver? Does anyone know the Heimlich maneuver in the courtroom? I'm sorry, I have a lifesaver in my mouth. I didn't know we were going to go back on the record so quickly.
And I just can't see the relevance of actually having her open that. I don't see how that's going to be, make any material fact more or less likely for the jury's perspective. And then I also, again, in light of yesterday's incident with the slides, it seems like a bad idea. And so
It seems like a bad idea
But,
for the jury to see. Maybe
legally
we don't-
speaking, I would couch it in the form of a relevance objection.
All right, thank you. Thank you, Mr. Cruz.
Excellent.
Yeah.
I think the state is precluded from arguing relevance because they introduced the items into evidence. As your Honorable Court is aware, I before have asked the state, before they introduced any of it, I believe I asked Mr. Yalamachili when he showed them to me, to open the package. I believe I raised an objection with the Honorable Court. We don't know what's in the items. And I think it's even more relevant the fact that we had one incident where we opened envelopes and they were completely empty. So what's in the package is relevant in this case. I'm going to ask her, are those items she tested? And I'll go down that line of questioning once she's able to identify what's in the package. As of right now, the state is just presenting packages saying, hey, take it for what it is. That isn't authentication. We want to authenticate these items and then ask the witness questions about those items.
All right, thank you.
But I won't pass it to the jury solely.
Okay, well, let's talk about that moment. All right, hang on just a minute. Mr. Bill, is there anything else?
No, Your Honor.
Okay, thank you. Hang on just a minute.
Let me see if I can find any authority for the decision that for the ruling that I'm about to make. Excuse me, law intern, or I'm sorry, whoever it is that's sitting to the judge's right. Could you please look up some case law real quick and draft a little opinion for me to say why it's not
Thank you very much. All right. I'm
allowed
going
for-
to overrule the objection
Oh.
and allow Mr. Cruz to ask this witness to open the package, but I'm not going to allow it to be sent to the jury. I think that
Okay.
incident yesterday is indicative of the danger of doing that. There are methods if the jury wants to look at evidence that is sensitive, particularly during deliberations, and we take it up in the courtroom, we deal with it in that manner. I'm not necessarily making a finding that this is actually relevant, but you are on cross-examination. I'll allow you to do that. All right, anything else? All right. Well, I did tell them we had a restroom break. Can you knock on the door and see if they're ready? Thank you.
She swings that mic around like the cleanup on aisle 5 person at the Walmart. We have a WD-40 emoji for that. I'm gonna get to catch up on real time here a little bit.
Please.
What time did she say that we were going till today? 2:30? It's gonna be a half day. Half day. She's the chief judge in the county. Oh, well, that tracks. She texting? Look, wait. Who's she texting with? I mean, at least I don't know if she's texting actually, but she's looking at something down below. Look, wait. She Googling how to be a judge. Best ways to deny an objection. How to be a better judge. Oh, I forgot. Oh, wait. I have it. Look, for all of us, Tiny Jesus is here. Tiny Jesus is with us today. We're going to need all of his help. I told you when I was in Cancun, my sister found a Tiny Jesus at the resort when we went to see Dave and Tim, and I have now decided Tiny Jesus. Nurse Kim, who's also maybe a favorite of yours, also has a little Tiny Jesus, and sometimes we need to call upon him. So he's going to sit right here next to me on the. He's about the only person who can help us now. He's about the only person who can help us now is Tiny Jesus. Sweet, tiny Lord of Lords. Please watch over this trial and help Edrick Faust get justice for something he did not do 25 years ago, in my opinion. They've got zero evidence. Jesus, take the wheel. Tiny Jesus, take the wheel. Imagine if Jesus was driving, or Toonsis the cat was driving, and then Tiny Jesus was the co-pilot. That's exactly where we are right now. Is she doing Wordle? What do you think is she doing the Wordle right now? Hold the applause,
Now we're back
everyone.
On the record, I do want to tell everyone in the audience, since we have a number of people in here, and it's gotten busier since
yeah.
we started, and
That's
I don't
right.
know who was here yesterday, if anybody.
Cupcakes are here now. Cupcakes are in the house, yo.
So I'm just going to remind everybody in the audience that with the exception of the media who have been provided a Rule 22 permission, with the exception of attorneys who are here in the courtroom, who are also here in the courthouse, if you'll just tell them to hang on just a second. Thank you.
Do a little get ready with me.
With the exception of attorneys who are here in the courthouse, perhaps watching, but also doing business here in the courthouse, with the exception, of course, of law enforcement who is here, who needs to be in other areas and need to be on their cell phone. With those and the attorneys at the table, the exception of those persons, no one's allowed to use their cell phone while they're here in the courtroom. So if you have one, obviously make sure it's on silent, please. And please put it away. And thank you. The other issue that I want to bring up for counsel with regard to the ruling that we just made is I think it is probably best, and I'm going to make this part of the order, that only this witness handle the actual contents of the actual exhibit.
Yes, ma'am.
All right, thank you. You may bring the jury out.
Maybe, oh, sorry. Wait. Oh, you better hydrate, girl. You're going to need it. We could do a little get ready with me and Tiny Jesus. What do you think? Nothing's going to help the bags under my eyes. They are not carry-on, folks. These are full-size checked luggage.
Mr. Cruz?
Okay. Thank you, Your Honor.
Sorry, Rhonda.
Can you open the
Help
two
me,
envelopes
Rhonda.
that were provided to you?
Yes.
Can you hold it up,
Yeah. Do you want me to do one at a time or?
please?
Okay. So this is cuttings of item 2I.
And may I approach, Your Honor, just so I could get a better sight on it?
You may.
She's reading the chat. You guys keep me laughing. That is one of the reasons I love you so much.
And then this is cuttings of item 2J.
Felicia says she's Googling Haas to frame a man like Boo Radley. Polly Pockets Power Trip says she's playing Tetris trying to make the pieces fit. April says
Now,
she's
you agree
Googling
that the items that you received
Haas Long until I'm considered the most corrupt judge ever.
were cuttings of swabs. Is that correct?
Correct.
Okay. Inside of the tubes that you have, do you recognize those swabs as what you tested?
Yes.
Do you know where those swabs came from?
No.
The only information that you had about the swabs were that they were oral swabs. Is that correct?
Correct.
At any time were you advised that the swabs were over? Well, let me ask this. What year did you test these swabs?
In 2024.
You remember what month in 2024?
I can see on the envelope, it was October of 2024. I tested them.
October of 2024?
Yes.
Okay. Were you aware that these swabs were collected close to 23 years, well, past 20, close to 24 years prior?
At the time, no.
At the time she tested them, she had no idea that they were
Items
collected in 2001. I don't know. Would that make a difference?
that you tested, you don't know when, or excuse me, you don't know when they were collected. Is that right?
Correct.
You don't know where they were collected from. Is that right?
Correct.
You don't know who those swabs belong to?
No.
Okay, so you weren't given any of that information?
No.
You simply received a package labeled oral swabs.
Correct.
Okay. And question for you, you have the swabs up there with you. Would you agree that the, I may say this wrong, but the swabbing material, the cotton, in some places is pretty much white. Is that fair to say?
Yes.
Did you know that those swabs that you tested had been considered oral swabs for close to 24 years?
I would object to the characterization in that question.
All right. Most specifically, what's your objection?
I would object to the use of the word considered oral swabs versus labeled oral swabs.
I'll allow it, but you may follow up if you choose to do so with any redirect. Go ahead.
I'll
Right, can you
allow it.
repeat the question?
Sure.
Said I'll
Were
allow
you
it.
aware that the items that you received had been considered or labeled oral swabs for 24 years?
I was not aware of the past characterization of them.
Oh, really? Wait, so that you just
So you-
tested some
is it fair-
swabs and you didn't know if they were oral, vaginal, you had no idea what the swabs were from?
Fair to say that as you sit here today, you don't know if the swabs that you tested are the same swabs that were collected.
Correct. I'm only aware of what we received at our laboratory.
That's fair.
Checking Twitter to see if she was trending.
Of course, indulgence.
Jess.
My last question for you. You mentioned this is your first time talking about these tests. Are you aware of anyone else being asked to testify about the Lugol's iodine test in court?
Sustained.
Those are my questions. Thank you so much for your time.
Any redirect, Mr. Bolden?
Your Honor,
May this witness be excused.
please.
Any objection from the defense?
No, ma'am.
You are free to go. And you may call your next witness.
Thank you, Judge. I think that myself and Mr. Cruz need to review the exhibits that are going to be used with the next witness.
Okay. How much time do you need to do that?
I mean, a couple of minutes, Your Honor.
All right, go ahead and just do that. I mean,
If that was defense, she would have said, you should come here prepared. Last night, she made Mr. Ahmad Cruz, our new king defense attorney for the week, she made him do a Daubert hearing that he was not advised was going to take place last night by telling him you're supposed to be prepared at all times. But when it comes to Mr. Yamalam Ding Dong, aka Kalki Yalamanchili, the district attorney of Athens, Clark County, Georgia, he can take all the time he needs. He can take all the time he needs. He doesn't need to be ready. He just needs to be able to
yes, that's
close
probably
this
best.
case.
Thank you. The restroom right now, certainly
We're
you
not
can do that,
interested in
but
it.
we just
in
did
it.
take.
We're not interested in the truth world. We're only interested in a conviction. Let's go to the chat for a minute. Hopefully you're sharing my outrage this morning. Amanda Sark says, Melanie, I love how passionate you are about the law and getting justice. We need more lawyers and advocates like you in the world. Well, thank you so much for your 20 and for your compliments. And some people find me incredibly annoying, but I don't really care. Thank you. I appreciate you. Bethany says, according to ChatGPT, she graduated from California Baptist University in May 2022 with Bachelor of Science in Forensic Chemistry with a concentration in criminalistics. Does that give an idea of age? I love you with all my heart. Thank you, Bethany. Yeah, so she's probably like, maybe 25 tops. Well, I don't know. Yeah, something like that. She doesn't have a master's, but she's an expert. Thank you so much. Marcy Lies says this judge was a public defender for 18 years before she was appointed to the Superior Court judge. I appreciate you. You're 5. Allegedly Paris. This was a great comment, so I put it up earlier. Says this is very similar to YSL. They were allowing just about anyone to testify as an expert for the state. I didn't follow that trial because it was like, I think at least a year long. So thank you for coming in and telling us all the tea. Julie says, good morning, all you citizen crime analysts. I know it's like armchair detectives, Blues Clues. It's like everything all wrapped up into one trial. Thanks for your 5. Ruth Lasoki said this is where they're trying to add the only evidence against Faust, and it's extremely sus and questionable. Thank you. On top says, thank you for your super sticker. So much. Laura says, thank you for always standing up for injustice. Thanks, Laura, for noticing and for being here for 18 months. Tracy says, I never thought I'd see a judge more biased than Bev. I hope those sidebars are unsealed, although this judge doesn't seem to mind calling out Attorney Cruz in public for the world to see. No, she doesn't. Not a lot is done at sidebar here. That is one difference. I don't know, Karen, where you could send Cruz emails of support. I have no idea, but I'm sure you could Google his office and maybe there's a website and you could send him a little message. I wouldn't feel comfortable publishing any of his private information, but Google is your friend. Thank you for being with me for 7 months because I love you with all my heart. Chell says the defense can have a rebuttal witness, so the defendant is forced to use this non-expert. What? The defense can't have a rebuttal witness? Is that, I don't know where that came from. Did I miss something yesterday? Do they not have? I don't know. I'm confused with your question. Thanks for your 5, but that was the state's expert. Graham Tam says there's a lot of Bev going on here. Thank you so much. I know it. Maybe it seems like it could not possibly be the state's expert because they have an unlimited budget. That was the state's expert. Graham Tam, thank you for being here for 18 months. Says there's a lot of Bev going on here. And Karen says, Karen gifted 5 memberships. Thank you, Karen. You're the greatest. Thank you so much. You're the greatest. Jessica says, if this witness is the only one allowed to handle this evidence, who's going to show the jury when she goes home tonight? I don't know, because what do you mean? Well, she held it up. So, I mean, I think that's all that's necessary. I don't think that I'm confused by your question. She showed it to the jury, right? Also, did she even testify about the results of the testing? She just said that they were presumptively positive for saliva, but didn't connect it to any particular person, right? We don't know who it belongs to, right? Martin said, I think the state wanted to close this cold case. They chose someone who had a record and could not afford a high-powered defense. 100%, I agree. All to use it in a campaign ad down the road. Disgraceful. Yeah, and to show that the $5 million that they spent enacting the Baker Act was worth it to close cold cases, because the first cold case that they're going to close is Tara Baker's case. And thank you for your 5, slow 820, so very much. All right, let's go on.
Your Honor, I think we're going to have to address something with the court.
All right. Ladies and gentlemen, I am going to ask you to go into the jury room. Please don't discuss the case. We'll be with you shortly.
Didn't she just bring them out? Hold on a second. So she sent them out, right? Because he said he had to look at his exhibits. And then
State's Exhibit 136 makes.
Now she's got to send them back again.
Thank you.
Based on.
Jury room, please don't discuss the case. We'll be with you shortly. Thank you.
It's a joke.
All right, go ahead.
Thank you, Your Honor. This goes back to some pretrial rulings by the court based on the court's ruling and the defense's proffer that pursuant to the state's Saudi motion that Mr. Melton would be the only alternative suspect raised by the defense. The reports beginning with State's Exhibit 136 makes reference to an individual as a suspect who is neither Mr. Faust or Mr. Melton, and so the state would seek to redact that pursuant to the court's order. It's not relevant and under 403 would be confusing to the jury. As it relates to State's 137, same thing, there's an individual listed as a suspect who is not one of the noticed individuals from the court's ruling on Saudi motion. 403, again, it would be excluded. I don't know that the state is going to get into, or well, 138, yes, again, same individual's name needs to be redacted in the suspect line. As it relates to 139 and 140, Judge, there are a number of individuals' names on here that kind of fall into that same category I was speaking of previously. They are not Mr. Melton or Mr. Faust, and thus their names need to be redacted pursuant to the court's ruling because it would be confusing the jury under 403. So that would be the state's position, and I understand after discussing that with Mr. Faust, the defense is not in agreement as to that.
All right, thank you. Mr. Cruz, anything, sir?
Yes, ma'am.
All right.
A big portion of this case is the police's investigation and the way that investigation was conducted. Our position would be that other suspects that were looked at should be considered by the jury, as opposed to making this case solely about Mr. Melton and Mr. Faust. As I stated in my opening, Your Honor, the jury's job isn't to determine whether or not Mr. Melton committed this crime. The jury's determination is to determine whether or not the state has presented enough evidence that Mr. Faust is the person that committed this crime. I do believe that in regards to the 401 objection, it is relevant. Law enforcement looked at other individuals. I believe in the reports, since I'm making the argument, they look at other individuals, but they don't have their, in this particular case, hair fibers, because it's hair, excuse me, their hair, because these are hair tests. They have these individuals listed as the suspect, but they don't have any of their biological material. So it is relevant. I don't think it'll confuse the jury because, again, as I explained to the court, you have this person listed as a suspect, but in the report, you don't have this individual's biological materials. So I would ask the Honorable Court to allow or restrict the state from restricting that individual's name off of the testing form, Your Honor.
Thank you. Anything further? Mr. Yalman-Chili, it's your motion.
I think the law stands for a contrary proposition, which I argued to the court.
All right, thank you. So, Mr. Cruz, your argument is in direct violation and contradiction to all of the orders that have been entered in this case. And I've said many times, and I will say it again today, that the defense had the responsibility, if it chose to enumerate other possible suspects, that not only did they have to, by law, provide the proper notice to the state that they were going to seek to introduce evidence as to other persons, but also a hearing needed to be scheduled pursuant to that notice. That notice is in the form of a motion. And we've talked about this many times. That has not been done by the defense, with the exception of Mr. Melton. And we had that hearing. And that evidence that both parties sought to admit with regard to Mr. Melton was agreed by the parties and accepted by the court that would be admissible. I mean, not all of it, but just in general. But any other mention of any other suspects or things of that nature were prohibited based on the rulings by this court in several hearing days that we have had. And so I say that again to say that because of those rulings and because of the legal procedure that was not enlisted by the defense to get the proper permission to be able to talk about other possible suspects, it is prohibited. It is also not relevant based on the prior rulings. I agree with the state that under 403, confusion of the issues would be paramount in this moment. And so I'm going to order the state to redact those particular exhibits. I think they're 136, 137, 138, 139, and 140. Am I right about that?
Yes, Your Honor.
All right. I'm going to order the state to redact those exhibits, as we previously discussed, with regard to those rulings. I mean, I think that's, we've kind of gone over this.
May I respond, Your Honor? I'm
You
happy
may.
to heard. And I believe I may have explained it wrong. I am not saying that we want to say that this third person did anything. We're saying that it's relevant because it goes to law enforcement's investigation. And please forgive me for I probably didn't state that the first time, but they're saying, hey, this person was a suspect. However, the test is biological testing. The relevance for us is we're showing law enforcement said this person is a suspect, not because we're saying they committed the crime. We're saying, look at the work they did. Person A is a suspect, but they don't have any of person A's biological material. And please forgive me if I misstated that the first time.
Well, I did actually understand this part of your argument.
Understood.
I did. And with regard to the comments you're making about the police work and how they conducted, I'm not making a finding about that issue. But my ruling stands
Yes, ma'am.
because the defense has failed to provide the proper motion and notice that the law requires in order for the court to then make a determination as to even whether that evidence should be admitted. And so because of that, regardless of the reason that the defense or any party wants to introduce that evidence, it is prohibited.
Yes, ma'am.
All right, thank you.
Thank you.
How much time do you need, Mr. Yellow-Chili?
Just a couple of minutes,
All right.
Judge, and then I'll hand it to Mr. Cruz
Okay.
to make sure he has no objection as to form.
All right.
I understand he objects in general.
Okay.
And then one request I would make of the court is, we can redact it for today with a Sharpie. We also have the ability, though, to black it out digitally.
Congratulations on your
Reprint the report
technological
without
advances.
blackout. And so at the appropriate time, I'd ask to, I guess, submit an alternative redacted version of the exact same report. Obviously, it's just a digital file at that time.
All right. I guess my question for the redaction process is, do you need to make a copy of that exhibit and then do it, or?
I think it's fine.
All right, I'll just leave that.
Pretrial rulings were issued in which it apparently was determined that Chris Melton was the only third-party culprit that the defense would be allowed to point to outside an additional motion to allow them to point to other third-party culprits or other potential suspects. And so jury's not going to get to hear about anybody who's listed as a suspect on any of these reports with regard to this hair analysis that their next expert is going to testify to. I don't know if the pretrial motions were streamed. I do know that there are a couple of local stations that are streaming this live. One of them is, I think, Fox 5 Atlanta, and the other one is maybe Atlanta 11. And so I don't know if they streamed any of the pretrial hearings. It would be interesting to know. If anybody finds out, be sure and let me know.
To you. We just need to make the record clear. All right, we will take a 10-minute recess. I'll be back on the bench in 10 minutes.
Stephanie, I was going to say the same thing, but I thought I'd get a lot of heat for saying that, and I'm going to just delete your comment. But I do agree with you there. So if you want to email me and share your thoughts, I would love to hear them. Counselor, thank you so much. You're the greatest. Let us fast forward to what is almost real time at this
It
point.
can be on the record. It's fine.
It is not abnormal to have the DA trying the case. Some jurisdictions it is, like Michael Marcy has never tried a case. And so to have Michael Marcy trying a case or sitting there would be unusual. However, this district attorney, Kalki Yamalama Ding Dong, apparently is a trial lawyer. And so he's there second chairing, or maybe first chairing Chris Bolden. I'm not quite sure who's the lead here.
All right, we are back on the record. Has the state finished the redaction?
We have, Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it. It just came to our attention. But can we do that initially off the record or in chambers to discuss how the court wants to
In chambers?
Yes.
to talk with her?
We
Hold
are
on.
back on the record. Has the state
Wait.
finished the redaction?
We have, Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with.
He's looking at his cell phone and he's like reading like a text message or an email or something. This is very odd.
Mr. Cruz about it. It just came to our attention. But can we do that initially off the record or in chambers to discuss how the court wants to handle it?
Yes.
What? He's ambushing the defense as usual.
We can do it in chambers if you want to do that.
You want to do it in chambers? You want to go
Um,
into the super secret chambers?
Let me see y'all at the bench just for a
It's
minute.
like Harry Potter. This is yeah. he couldn't add the other witness that he wanted to add, but now something has come to his attention. And now he's showing Mr. Cruz something on his phone. I'm not sure what it is. Have they discovered that we're all paying attention to this case and that we're cheering for Mr. Cruz? I doubt it. But what do you think they're chatting about on his phone? And now Cruz is coming back and he's like, what, dude? What? It's like a little argument going on there. What is the drama? Tiny Jesus, please save us. I got this tiny Jesus has Jesus loves you, it says in a little, he's got a pink sash on. Now they're doing a little powwow between Mr. Hill and Mr. Cruz. I believe that Mr. Hill is his co-counsel. Yeah, Zoe says typically and I would agree, typically super secret squirrel conversations with the judge during trial involve a juror and potential misconduct. That's my guess. That's what Zoe says.
Okay.
Zoe's wicked smart.
Oh, no. Do you want to tell the judge that?
Okay. All right.
Someone has come forward with information on this case. Please, if there's anybody out there who has any information on this case, please come forward. Oh, this is not normal. No, I mean, it's not abnormal, but we haven't seen it here. They've never gone into chambers during this trial. All right, let's fast forward a bit. Let's see where we are. Looks like they left the room for quite some time. Wait, is she back? From outer space. Hold on, I thought I saw her for a second.
Started. Is there a Jessica Berryman present in the courtroom?
Wait a second. Who? Who's Jessica Berryman? What? That's not our cupcake.
All right. We are back on the record. Before we get started, is there a Jessica Berryman present in the courtroom?
I mean,
I hear no response. All right. Counsel for the state, are you ready for the jury to come in?
We are, Judge.
Ms. Cruz?
okay, what? Who's
Yes, Your Honor.
All right.
They
Thank you. You may
outed
bring the
her.
jury in.
who's Jessica and why are they outing her? Jessica Berryman, tell us everything. What the F was that actually? Oh, is somebody live tweeting from the courtroom? Oh, I don't know, but I'm sure you guys will figure it out. Now we need to know.
Mr. Yalamachili?
Sir, if you would raise your right hand. Do you swear or affirm testimony you'll give to the jury today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
Larry Keith Peterson, LARRY KEITH PETERSON.
And sir, are you currently employed in a full-time capacity?
I am not. I'm retired.
All right. And when's the last time that you worked in a full-time capacity?
I was retired from the GBI Crime Laboratory in 2008. So I was employed there from 1978 to 2008. In 2008, I was employed by the U.S. Army Criminal Investigations Laboratory until I retired from there in 2017.
Okay. And going back to before your employment, what type of educational background do you have?
Yes, I have a Bachelor of Science in Forensic Science from the University of Central Florida.
And what was your first job after college?
Was employment at the GBI Crime Laboratory.
Okay. And so between the GBI and the United States Army, how long did you work in forensic sciences?
That would be almost 40 years.
And as it relates to, we talked about your educational background prior to starting work at the GBI. What type of training did you receive when you went to the GBI?
Right. So scientists at the GBI trained me in various aspects of trace evidence analysis. During my employment, there was also attendance to seminars and classes on the evaluation of trace evidence, including professional organizations and, personal relationships with other scientists.
Do you have any professional affiliations from your time working in forensic sciences?
Yes, I was and currently in emeritus status with the American Board of Criminalistics, also American status with the American Society of Trace Evidence Examiners. I'm a retired member of the American Academy of Forensic Scientists and retired and past president of the Southern Association of Forensic Scientists.
And as it relates to the Southern Association of Forensic Scientists, did you ever serve as president of that organization?
Yes, I did.
All right. Have you ever had any publications regarding forensic sciences?
Yes, I've published several articles on trace analysis.
And have you ever been recognized for your work in forensic sciences with any types of awards?
Yes.
Your last title at the GBI or job responsibilities, what was that?
The title was a microanalyst, generally a person who is responsible for evaluating what's generally considered microscopic or very small amounts of material.
Okay. Did you have any leadership roles as it related to your time in the trace evidence section?
For approximately the last 9 years, I was deployed with the GBI. I was the trace evidence not supervisor, but I was supervising the competency as technical leader of the section.
And you said supervising the competency as technical leader of the section.
I need to interrupt this broadcast for a very important announcement, and that is thank you, Venus Blue, for solving the mystery of Jessica Berryman. And here it is. She just posted just now on, this looks like Facebook, Jessica Berryman. Lisa, I'm at home in Loganville now. Don't be calling my name like that. Apparently, she has possibly been live streaming the trial, and I don't know why she's relevant or why anybody brought her to the attention of Yama Lama Lama Ching, Yama Lama Ding Dong, but there she is out there. Thank you, Venus Blue, for doing the Lord's work. And back to your regularly scheduled programming. Go follow her on Facebook, I guess. I guess that's what that is.
Can you elaborate a little bit on what that means?
Generally, it's the person who is responsible for reviewing and generating revised protocols and procedures, and also oversees proficiency testing.
Okay. And have you ever testified as an expert in any fields?
Yes, I've testified on over 400 trials in various aspects of trace evidence.
Okay. And as it relates to various aspects of trace evidence, have you testified as an expert in the field of human hair analysis?
Yes.
Okay. And have you testified in the states, in the courts of the state of Georgia?
Yes, state courts as well as federal and military as well.
And Your Honor, at this time, I would move
Oh,
to
wow.
tender Mr. Peterson as an expert in human hair analysis.
All right, any objection from the defense?
No, ma'am.
This witness is qualified or tendered as an expert in human hair analysis. You may
Thank-
proceed.
Thank you, Judge. Mr. Peterson, next, I would like to talk to you a little bit about human hair analysis. And I would like to start with the science behind human hair analysis. Do human hairs contain any unique or variable characteristics?
Right. So the science of comparing hair is that a recognition that hair contains several basic parts. So there's a cuticle outer structure of a hair. There is the basic protein, the main portion of the hair called the cortex. Some hairs contain what's called a medullary structure, a medulla, which is kind of an air-filled tubular structure that can appear down in the center of some people's hair. So based on, and the cortex of the hair contains the pigment granules, which gives the hair its color. So there's an evaluation microscopically of all of these features, both from a gross microscopic or a low power magnification view, as well as a detailed comparative, detailed microscopic comparison with a question and a known hair, an attempt to determine if there's an association between those two samples.
And so as it relates to the variable characteristics that hairs can have, are there certain characteristics that have a lower rate of occurrence and will be more unique as opposed to other characteristics that have a higher rate of occurrence and less unique?
Right. Some hairs possess fewer characteristics than others just based on the amount of features that are available in the hair. For example, a very fine diameter blonde hair would have fewer characteristics to observe than a larger, more heavily pigmented hair.
Okay. And as it relates to hairs, an individual strand of hair, is that uniform from one side of the hair to the other side of the hair?
No. In the examination process, it's understood that the root end, or what we call the proximal end of the hair, would have different characteristics as you progress along the length of the hair towards the distal or upper end. It's just a natural progression over time, how hair changes as it grows.
And now I want to shift with you to the process of conducting a hair analysis. Is there a scientifically accepted process for conducting that analysis?
Right. So as I described, so in the process of procedure, you would start with the mounting or the collection of the hair, whether it was submitted as a collected hair or it could have been submitted as an item of clothing or something else. And then hairs would be recovered in the laboratory. However that process happened, the hairs would be mounted on a glass microscope slide in a mounting media to allow for its closer examination, which would begin with the stereo or low power magnification around 10 to 40 magnification. And in that classification process, we can look at the overall length and color, the shape of the hair, give some idea of maybe some racial origin information, certainly body area origin as well, and can be the first step in the association or the elimination of a question hair from a known hair sample. So a question hair would be one of unknown origin. It's a hair recovered from a crime scene or something of unknown origin. And we would have known hairs, a collection of hairs that represent the known hair of a particular individual. That range of knowns would be fairly tight to one another, but even hairs collected from a single individual is not going to be identical to one another, but they're going to be very, very close in characteristics compared to known samples from other individuals. And so in the comparison process, it is if it's not eliminated at the stereo microscope, it's transferred to a comparison microscope, which is where light is transmitted through the hair samples on two microscopes. The two microscopes are hooked together with an optic bridge so that you can view the internal characteristics side by side. And at the end of that process, if following the examination of the hair from the entire length of the hair, if that question hair falls within the range of the known sample, we can conclude that that hair is associated with or could have originated from that person. If it fails in that examination at any stage, it would be eliminated as potentially originating from that person.
As it relates to this particular case, in the murder of Miss Tara Baker, were you asked to conduct certain hair analyses as part of your work at the GBI in this case?
Yes, in 2001, I was employed by the GBI laboratory and performed examinations on the Tara Baker case.
Okay. And so what I'm going to do at this time, Your Honor, I'll show Mr. Cruz what I'm going to hand to the witness, but I'm going to hand the witness some exhibits that have already been admitted into evidence.
Mr. Cruz looking skeptically at just about anything nowadays, as we all are. Thank you, 302 girl who said, I went to Cruz's website last night and told him Mel was covering and we are outraged and continue to fight the good fight.
All right, Mr. Peterson, I'm going to hand
Thank you.
this
Grade 10.
little box lid that's full of some slides as well as some envelopes. Starting with the envelopes, do you mind going through those and taking a look at them?
Are these the same envelopes that are empty?
Yes, sir.
All right, and so do you recognize those envelopes?
Yeah, these are samples submitted to the laboratory for analysis. They all contained a unique case number for the laboratory, 2001-1002454. And that was the case number associated to the Tara Baker case.
And what are the exhibit numbers on those envelopes?
We have defense exhibit, I believe that's 17, 16, and 11.
Okay. And let me ask you this. We talked about the process that the GBI lab goes through when hair analysis is being conducted. Is it the typical process of the GBI crime lab after a hair that's being analyzed has been mounted to remove it from its mounting, put it back in the envelope and send it back to the law enforcement agency? Or is it the typical practice for it to remain on the mounting that it was placed on for analysis purposes?
Right. No, it would be left on the slide that it was removed to, and that would become its permanent status at that point.
Okay. As to those envelopes that I've
Guess you should have figured that out before you entered those empty envelopes into evidence, sir.
handed to you, are they sealed or are they open?
They appear that they have been cut open from one end.
Okay. Do you see anything on those envelopes that would help you recognize whether or not you had ever interacted with those envelopes?
Well, yes, each envelope, in addition to the laboratory number, has my initials on the envelopes.
And what I'd like to do is retrieve those from you now. And Judge, I'd ask to publish them on the Elmo.
All right, ready?
And I'm going to start with State's Exhibit, or I'm sorry, Defense Exhibit 11. And I just want to point to one part of this. What is that my finger is next to there?
That's the initials that I use on evidence.
Okay. And Defense Exhibit 16. I'm going to flip it around the other way. Sorry. What's that I'm pointing to?
Also are my initials.
And lastly, Defense Exhibit 17. And right there, what am I pointing to there?
Yes, my initials.
The hairs you received I think you already indicated those would be mounted. When they are mounted on a slide and then maintained in that medium, I want you to review now the slides that are in front of you and let me know when you've had a chance to look through all of those.
Earlier recognized. Yes, I believe these are the slides that I had earlier recognized, that these are boxes containing the prepared slides with mounted hairs.
And I'm going to retrieve one other thing, and then I am going to have some questions for you about that.
What's worse than a kangaroo court? Correct answers only. Go.
Retrieve these before I got you on the witness stand.
You're called the snark tank for a reason.
All right. I'm going to show Mr. Cruz what's already been admitted into evidence as state's exhibits 108, 109, 110, and 111. Yep. And Mr. Peterson, I'm going to hand you those items now. And I'm going to ask you the same question that I asked you about the 3 envelopes. Do you recognize those bags, is what I'll refer to them as?
Yes, sir.
And how are you able to recognize them?
Well, each of these exhibits contains the laboratory unique case number 2001-1002454, as well as my initials on each item.
Okay. And did those appear to be in substantially the same condition as when you received them from Athens Clarke County Police Department?
Yes, there may be some additional seals, but the container itself is the same.
Okay. All right. Now, going forward to the slides in that box in front of you, you had a chance to review those. Do you mind telling the jury what exhibit numbers you are looking at?
Well, I may not say these in order, but I will just go down through the list of the boxes. So I have States Exhibit 124, 122, 125, 114, 117, 118, 121, 123, 119, 120, 116, 115, as well as Defense Exhibit 31.
All right. Thank you, sir. And I think, did you previously testify that these include the slides that you conducted your analysis on?
Yes.
Okay. Did you generate any reports in association with the analyses that you conducted?
Yes. I produced several reports.
I'm going to hand you first what I've marked as States Exhibit 136 after I show it to Defense Counsel. And I'll actually go ahead and hand you States Exhibit 137 as well.
Hey, Kim, it's crazy out there. It's crazy. Go back and start from the beginning if you guys haven't watched it. I mean, if you guys are just tuning in today, you've missed a lot. This is a wild trial.
And Mr. Peterson, looking at State's Exhibit 136 first, do you recognize what that is?
Yes, so this is an official report issued by the laboratory that shows the results of my examinations.
And what date is that report from?
February 2nd of 2001.
And does it appear to be a true and accurate copy of your report associated with your analysis on that date?
Yes.
And Judge, I move to tender 136 at this time.
Any objection? It is admitted.
All right. So looking at 136,
All right.
does it have certain numbers associated with items that you received?
That's correct. So when evidence is submitted to the laboratory, it's given an exhibit number in addition to a case number.
Okay. And so those numbers that we're about to refer to, those would be, by your terminology, an exhibit number. Is that correct?
Correct.
Okay. Was there an exhibit number 2?
Exhibit 2 is a sexual assault kit identified as that from Tara Baker.
And as it relates, was there an exhibit number 8?
Yes, exhibit 8 is identified as question hair recovered from the buttocks of the victim, Tara Baker.
And was there an exhibit number 9?
Number 9 was an item identified as question hair from the torso of the victim, Tara Baker.
And then where did exhibit number 10 come from?
10 is identified as question hair recovered from the left hand of Tara Baker.
It also, as part of this submission for your analysis, were you given known hair samples from any individuals?
Yes, that shows 5 known hair samples that were submitted on that same day.
And starting with exhibit 21, whose hair sample was that?
Known head hair of Chris Melton.
And exhibit number 22?
Known head hair of Christopher Hall.
And exhibit number 23?
Known hair of Jeff Hall.
And exhibit number 24?
Hair sample of Ashley Peavy.
And then exhibit number 25?
The hair sample of Valerie Lang.
Okay. And as part of that sexual assault sexual assault evidence.
Those are all the people who might have been in the apartment that they knew of or lived in the apartment. Valerie and Ashley were the roommates. They've both testified already. And the 2 Chris's and the 2 Halls. Well, there's 3 altogether. Chris Melton, Chris Hall, and Jeff Hall. The other 2 boyfriends. Chris Melton was Tara Baker's boyfriend.
Collection kit of Miss Baker, would there have been known head hairs as part of that kit?
Yes.
Okay. So now we got the known head hairs of Tara Baker, Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang. Is that correct?
That's correct.
Okay. And then as far as hairs for which you are being asked to do a comparison analysis to see if there are any associations, you have a package identified as containing hair collected from the buttocks of the victim. You have package containing hair collected from the torso of the victim. And then you have a package containing the hair from the left hand of the victim. Is that correct?
That's correct.
Okay. I want to start with the comparison between the known samples in exhibits 2 and 21 through 25 against the hair collected in exhibit 8 from the buttocks of Miss Baker. Did you perform an analysis related to that?
I did.
Okay. And what, if any, opinion do you have based upon your findings as it relates to Exhibit 8?
Exhibit 8 revealed that there was 1 head hair microscopically consistent with the known hair of the victim, Tara Baker. There were 2 hairs inconsistent with the known hair of Ms. Tara Baker. And subsequent comparisons show that they were consistent with the known hair of Ashley Peavy.
And so let's talk about consistent with the known hairs of an individual. What does that mean?
It means basically that they had a correspondence in their microscopic characteristics that in comparing the question hair to the known hair, they possessed sufficient similar characteristics to they could be included as a possible donor of the hair, that either would be from that person or another person possessing hair with the same characteristics.
Okay. And so as it relates then to Exhibit 8, and please correct me if I misstate anything about your findings, of the 3 hairs that were of a quality that could be analyzed, 1 was consistent with Miss Baker and 2 were consistent with Miss Peavy. Is that correct?
That is correct.
Okay. I want to go forward to Exhibit 9, which is collected from the torso of the victim. As it relates to your analysis on Exhibit 9, what opinion were you able to develop based on your analysis?
Exhibit 9 indicates that there were numerous head hairs consistent with the known hair of Tara Baker, the victim. 1 head hair inconsistent with the known head hair of the victim. And then further microscopic examination of that particular hair against the known hair of Valerie Lang showed them to be consistent.
So the hairs that were analyzed there were some that were consistent with Miss Baker, the victim, and then the one that was not consistent with Miss Baker was consistent with Miss Lang. Is that correct?
That is correct.
Okay. And so as it relates to the hairs that were found to be consistent with Miss Hall and Miss Lang that were recovered from Miss Baker's body, those were also compared against Mr. Melton, weren't they?
Yes.
Okay. And what was your finding regarding those hairs as it related to Mr. Melton?
Well, the hair was eliminated as potentially originating from him.
Okay. So as it relates to items 8 and 9, those hairs could not have come from Mr. Melton. Is that right?
That's correct.
Okay. And now I want to get to Exhibit 10, which is the hair from the left hand of Miss Baker. Based on your analysis of that hair, what opinion did you form regarding that hair?
The hairs identified from the left hand of Tara Baker, there were several head hairs and 1 pubic hair, all of which had the similar characteristics as Miss Baker's own hair.
So they were consistent with Miss Baker's hair. Is that correct?
Correct.
And so that head hair, or I'm sorry, not head hair, that hair that was recovered from Miss Baker's left hand, was it compared with Mr. Melton as well?
Well, the head hair would have, yes.
Yes. And so that head hair that was compared with Mr. Melton, what opinion did you form as to whether or not that head hair could have come from Mr. Melton?
He was eliminated.
Okay. And what does eliminated mean?
Did not have corresponding microscopic characteristics.
It kind of looked like it could have been hair from her own head. Kind of, sort of, maybe. The left hand hair kind of came from her own head, maybe, I guess. When did he say he did this testing? Right. Did the hairs have roots for DNA testing? Did they forget to test them? I have so many questions.
As it relates, sir, to Exhibit 130, or yes, 137, states 137, do you mind telling me what that is?
Again, this is an official report which I produced under the same case number 2001-1002454, the case number for Tara Baker, issued on February 27th of 2001.
And Is that appear to be a fair and accurate copy of the report that you generated based on your analysis on that date?
It is.
Judge, I moved to tender states 137 at this time.
Any objection? It is admitted.
And as it relates to States Exhibit 137, Mr. Peterson, it makes reference to Exhibit 2 again. Is that correct?
It does, yes.
Okay. And Exhibit 2 is the sealed sexual assault evidence collection kit of Miss Baker. Is that correct?
That's correct.
Okay. And in there, it has listed in Exhibit 12. What is that?
Exhibit 12 is identified as there's a power transformer.
Okay. And did you have an opportunity to process that?
Pay attention to this. This is the power transformer that was on the cord that was wrapped around her neck that strangled her. I don't know that we heard that the hair in her hand was Melton's. I thought we just knew that the hair in the hand was Caucasian. That's the way I remember the openings. That there were no African American hairs found on her at all.
Item for any kind of trace evidence?
Yes, hairs were recovered from that item.
All right. And so this power transformer, the hair that you analyzed that was recovered from that, what, if any, opinion did you form?
There were several hairs that were unsuitable for comparison. They did not possess enough characteristics to produce a meaningful comparison. In addition, there was one head hair which was suitable for a comparison. And additional examination comparison of that hair showed it to be consistent with the known hair of Chris Melton.
Chris Melton's hair,
Okay.
allegedly,
and so-
Chris Melton's hair was found on the power transformer of the cord that was wrapped around the victim's neck to strangle her. Okay? Why are we here?
So that's a separate thing than anything that was found on Miss Baker's body, though. Is that correct?
I believe so, yes.
All right. I want to go back now to exhibit number 10 in the hair that was in Miss Baker's hand that was consistent with her and eliminated Chris Melton. Have you had other occasions where you have examined hair that's been found in the hands of a homicide victim?
Yes, I have examined a number of cases, a large number of cases where hairs were recovered from the victim's hands. And the vast majority of time, the hairs were always consistent with the victim's own hair.
Okay. So this
She also, we know her routine was that she would blow dry her hair every morning and she had tons of hair. Okay, let's move on. Where's the evidence pointing to Edrick Faust? Where's that?
finding wasn't an unusual finding then, is that fair to say?
It was not.
Okay. If I could have just a moment, Your Honor.
And the cuts all over his hands, right? All over the hands of
Mr. Peterson,
Chris
thank you
Melton.
very much. I don't have any other questions
That's all
for
you
you, sir.
got?
I'm sure Mr. Cruz will have some.
Mr. Cruz, cross-examination.
Mr. Peterson, thank you so much for your time. The state asked you about the power transformer and the hair found on the power transformer. Do you remember that?
The notes reflect that it happened. This case happened a long time ago.
Correct. My question is, do you recall the state asking you?
The case happened a long time ago, but your testimony was literally 20 seconds ago, sir. They had fingernail clippings. We haven't heard about any results yet, Maggie.
Remember that? The state asked you about the power transformer and the hair found on the power transformer. Do you remember that?
The notes reflect that it happened. This case happened a long time ago.
Correct. My question is, do you recall the state asking you about a power transformer and hair found on the power transformer?
Well, I mean, we just discussed it. Yeah,
Yes, sir.
yes.
Okay, excellent. You don't know where that power transformer was located in relation to Ms. Baker's body, do you?
No, I do not.
I'd like to go over some of the hairs and the examinations you conducted. Is that okay?
Okay.
He didn't realize she was strangled with the power cord and the transformer on it. But, you know, no big whoop. He's just there to testify about his findings, I guess. You know, it's cool.
And I'd like to establish something first. So would you agree that Caucasian hair is different from African American hair?
I would agree.
Okay. And would you agree that based on your profession and expertise, it is easy, Caucasian hair is easily distinguishable from African American hair? Is that fair?
The vast majority of times, yes.
You examined a hair from the buttocks of Miss Baker. Do you recall discussing that?
Yes,
That hair was not consistent with African American hair. Is that correct?
that's correct.
You examined the hair from the torso of Miss Baker. Is that correct?
That's correct.
That hair was also not consistent with African American hair. Is that correct?
That is correct.
You examined hair from Miss Baker's left hand as well. Is that correct?
That's correct.
And you would agree that hair was also not consistent with African American hair. Is that correct?
I agree.
We discussed the power transformer, but you examined hair from the power transformer. Is that correct?
Correct.
Okay, and the hair on the power transformer was also not consistent with African American hair. Is that right?
That's correct.
And I believe you testified that the hair found on the power transformer was consistent with Chris Melton's head hair. Is that right?
That's correct.
You even examined the hair found on Ms. Baker's wallet. Do you recall that?
There was a hair identified as from the victim's purse, I believe.
From her purse?
It's identified as a purse.
Okay. And that was a pubic hair. Is that right?
No, I believe that was a head hair.
Your Honor, I would move to introduce Mr. Peterson.
Well, show him his report. Show him his report if you need to correct him.
Course indulgence.
And Your Honor, I would have an objection. I don't believe that the items that Mr. Cruz is asking this witness about have been tendered into evidence by either party.
Of course they haven't, because you don't want the jury to
prior-
see them.
Prior to questioning the witness about the items.
Go ahead, sir. Yes.
Well, I disagree with that, Your Honor. I asked him a question about testing that he's conducted. The testing is within this witness's personal knowledge. He has gave a statement that is inconsistent with the report that he's written, and I'm introducing this report as a prior inconsistent statement.
Let me see counsel at the bench for a minute.
He's entitled to wide latitude on cross for everything this guy tested, but it's not an inconsistent statement. He just needs to refresh his recollection with it. He needs to do it a different way. I'm sure he tested a lot of things and a lot of hairs, and a lot of stuff that the prosecutor does not want the jury to know about. Right. And the speaking objections by the DA are absolutely coaching the witness. And if you haven't been here, Martin, for this whole entire time, the witness has been in the room every single time objections are argued. And every single time the jury's been sent out of the room, the witness is allowed to remain on the stand and listen to the whole entire thing. It is insane. I don't know where you practice, Martin, but this is insane. Thanks for putting the law in the chat so we can put it up on the screen. So hopefully we're sending good vibes out into the universe. And, you know, assistance, the SOS call has been heard. I think we're a couple of seconds behind. We can scooch a little bit forward. Look at the judge's eyebrows go up and down on. Will they call Chris Melton? That's what I want to know.
Thank you. All right, ladies and gentlemen, I'm going to give you all your lunch break now. And so it has arrived. So if you'll go into the jury room and we'll present it to you, we're going to be back on the record
We're
in
going to
40
present you
minutes.
your lunch.
And please don't discuss the case. We'll see you at 1 o'clock.
You're going to have a lunch presentation right now. Cracker Barrel, what do you think they got them for lunch today? Martin Vale is Richard Gere from Primal Fear. Well, that's one of my favorite movies, actually. As you know, I did sue the Catholic Church on behalf of many, many victims and survivors of clergy SA. So that Primal Fear is one of my favorite movies. Let's move forward a little bit. Nice fluorescent lighting in that courtroom, eh? All right, well, this is where we are right now. With an objection on the table? Hello? They said Chris will take the stand. I wonder, says Sunshine. Always seem to be on real time. Yay on us. What time did she say she was breaking today? 2:30? It's 12:30 right now. Ed Norton. Oh, Ed Norton was so good in that movie. Venus Blue, you put this in earlier, and I didn't want to spoil it for everyone, but the man who did the podcast just said that the hair in Tara's hand was her own. Have we heard that? No, we heard that. That was done in voir dire. This, oh, your cat is so cute. Is that a real cat? Half black and half orange. They did a voir dire of this witness this morning outside the presence of the jury, and he said it then. And then he was just allowed to say it just now on the stand. So there's that. Thank you for your 5. And Sandy says, binge watched all last night to catch up. Retiring soon after 30 years in state and federal law enforcement. And this case tops the insanity cake. Lady Justice is using blindfold to hide from embarrassment. Glad we're all together. Thank you, Sandy D. For 10, I appreciate you so much. And Luna says, this judge triggers me and reminds me of my last boss who fired me after 15 years at my job. She was just as condescending, gaslighting, and belittling. I'm a disabled mom of 2 kids with special needs and made accommodations possible. Thank you so very much for your super chat. I'm so very sorry about your last boss who sounds like a real jerk. Joanne said, has the prosecutor mentioned defendant's name in 5 days? I don't really think so. Thank you, Joanne, for your super chat. And Jadzia says, I love you with all of my heart. She's been here for 18 months. And Crazy Cat Lady has been here for 6 and says, has Faust even been mentioned by the state? Maybe once or twice. Cupcakes for Justice is here said, did they find these people on the island of misfit toys? I think so, probably. Thank you for super chat. And Charlie from Australia says, you mean the hair that was supposed to be in the sealed envelopes? Yeah, but then it was on slides, and I think they explained that. And yeah, it was not in the hairs. Yeah, it's a whole thing. It's just another Michigas ridiculous portion of this case. Just a whole big mess. It's a whole big mess. Thanks, Charlie. Carrie says, hope you're feeling better. Sent you an email regarding this case. It seems we're not alone in our outrage. Thank you very much. I'll take a look for that when I can. Thanks for tuning in from across the pond. And Irish Wolfhound Mama says, I'm watching from Ireland, a country which is used to discrimination and injustice. Mr. Cruz is doing a fantastic job. He might be nervous or young, but his morals and ethics are shining through. Yeah, he is a justice warrior. Thank you, Bethany, for sending me an email. Happy 2-month anniversary to us. Yeah, that Wolfenbarger trial. Thank you, Ashley, for pointing out. That was another case in Georgia. That was another cold case. It was something like 20 or 25 years old. And he was acquitted, right? He was acquitted of the murder of his wife something like 20 plus years earlier. And the wild thing about that case, because I just looked into it a little bit, I just found out, I guess it happened, or the trial of the verdict came down in August of 2025, which was right after the Karen Reed trial. And so I just wasn't really fully knowledgeable of it when it happened. But what was wild about that is that he was acquitted of the murder of his wife some decades earlier, and his wife's father was an actual serial killer. That is wild. And so he was acquitted, right? Side Eyes just watched it on Baker. That's wild. But since it's already happened and we already know the ending, I don't know that we will actually cover it now, because we're more focused on current things. Thanks, Jamie. I'm not going to get into Jessica right now. Thank you so much for everyone who's sending me things. All right. Well, I don't know what happened with Jessica, poor Jessica, whose name was shouted out in court today, is really becoming a celebrity, I think, as we sit here today. Is Jessica in the courtroom? Anyone is Jessica in the courtroom? Thank you so much for Dr. Russell's gasp for sending a cash app. Says, thanks for bringing attention to this travesty. Thank you so much. I appreciate you so. You guys are sending me a lot of stuff that I just can't look at right now. And I don't want to dox anybody. Oh, thank you, Elaine, so very much. Oh my goodness. That's hilarious. All right. So Elaine, who we love Elaine. Okay, great. All right. So our cupcake has got to her car. She's gonna take down her notes. And Elaine, who's one of our amazing viewers and cupcakes and such a generous supporter of the channel, she said, I just called Mr. Cruz's office and spoke to his assistant or his secretary. I advised her we were watching and supporting and to please let him know there's a community watching and he's doing a fantastic job. She asked if I was referring to Melanie Little's show. And of course I said yes. She said they've had several calls from your people and they love the support. I'm not encouraging anyone to call his office. I said, try to find an email, but you guys are awesome. I just don't want them to be inundated with calls. And I certainly don't want the judge calling out my name in her courtroom. Elaine said that she asked if there was any kind of fund that we could donate to. And she said she's going to reach out to the family and see as his legal fees have been paid. That's amazing. And Elaine said, asked her to tell Mr. Faust or to tell Mr. Cruz, I guess, to please keep his chin up. And he's doing a fantastic job considering the circumstances. Also, she says that the jury makeup is 1/3. So out of 12, there's 4 African Americans and 8 white jurors. And that is according to, I guess, the office of Mr. Cruz. As far as we know. Oh, was I frozen? I know exactly why it's doing that too. All right. Well, I don't know. If I was frozen, that's a StreamYard problem. And it seems to be when I go like off the screen to look at a different tab that is in the browser on this screen. If I put it on my second screen, then it doesn't do that. I don't know what the hell it is. So it seems to be. Hopefully it was a good frozen shot of me. The judge told everyone to come back at 1. All right, so we have a little bit of a break. Day 5, and no evidence yet against Edrick Faust. I don't know why it's doing that. It must be a StreamYard issue. Because I know exactly when it happens, and so that's a problem for everyone. Here's the thing, Martin. I don't know if you're just watching this for the first time. He has asked this judge to reconsider her rulings 1,000,000 times, and she has said no every single time. Every single time. You can get into the court docket. It is public. Just go into the Athens, Clark County docket, and you can find his name in there, and you can get all the court papers that you want. There's a lot of improper rulings in this case. In my opinion. Yeah, Mike says, I'm so happy to know that Mr. Cruz and Mr. Faust are aware of how many people are behind them. This is the worst of the worst. It is the worst. It is one of the worst that I've ever seen. And it could be YouTube too. It could be. Since we're here, why don't we take a look at the judge's ruling from yesterday? Let me just go back to, and now I have to go to my other screen. So when I'm looking over here, that's my other screen, and then I won't freeze. Oh, Elaine, thank you very much for your very generous $200 Venmo. Says, let's go pull our hair out for another day. I sure appreciate your coverage. I hope you're feeling better. Thank you, Elaine. Not really, not 100%, but better than I was 2 days ago when I couldn't even come to the screen or have the patience for any of these shenanigans. Thank you, Charlene, for your Venmo. Says, thanks for all you do. Love your commentary. Thank you so much. Daniele Where do you go to get a cold case reopened? Or you could start with the district attorney's office in the district that you wanted to try and get a cold case reopened, and or the police department of wherever this cold case is pending. That is what I would suggest to you. Thank you for your Venmo. Anybody else has any other ideas on how she can try and get a cold case reopened for something that happened in 1999? Please let her know. Thank you, Leslie. I thanked you already. Maria, thank you very much for your Venmo. Says, just hugs, get rest, and feel better. Thanks for hanging in there with us. I appreciate you so much. I appreciate you so much. All right, so we see that they are going to be on lunch until 1. And what I have pulled up for you here is yesterday's ruling from this judge on why she's going to allow in the why she was going to allow in the expert testimony, why she was going to qualify that woman as an expert, and also the one that we heard this morning on the I don't know why I can't think straight, on the swab testing. Here it is. Hold on. I'm going to speed her ruling up a little bit because just want you to hear her reasoning for this. And this is from yesterday's Daubert hearing in the afternoon, in the evening, actually.
Testify at the trial to that effect.
Thank you, Mr. Bolden. All right, with regard to Mr. Cruz's motion, the first thing I want to emphasize is that the court has already allowed Ms. Licon to be admitted as an expert in the area of forensic chemistry and forensic biology. With regard to 702, I'm making a finding that the state has met its burden, and I'm making a finding for these reasons.
She's already got her answer. She's already got her decision written out. Okay, this was from last night when we saw the non-expert do somewhat a little bit of a Daubert hearing. Okay, she's reading from something clearly, right?
First, it is obviously very clear that this expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I mean, that's just clear.
It's just clear.
Anyway, I'm not going to say more about that. I think that you can't really argue with that. Number two, the testimony is.
I'm not going to say anything clearer than that. I'm just going to say that. I'm just going to say that. This is the first time ever that an expert has been admitted in any court. But that's all I'm going to say. I'm not going to say any more on that. That's all I'm going to say. That's all I'm going to say. Listen to that one more time.
Obviously very clear that this expert's, with regard to 702, I'm making a finding that the state has met its burden, and I'm making a finding for these reasons. First, it is obviously very clear that this expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I mean, that's just clear. And anyway, I'm not going to say any more about that. I think that you can't really argue with that.
It just did.
Number two, the testimony is based in this.
Ipsy Dixit, because I said so. She already made up her mind. Is this a ChatGPT answer? No, it can't be, because ChatGPT would have been way more involved.
This is under 702. The testimony is based upon sufficient facts or data. The argument that the defense has made about factor number 2 not being met because the evidence that she received may not have been sufficient is actually not what number 2 is about. The testimony that she provided was that she tested what she got, and whether the pieces of evidence that she tested were sufficient is a matter of weight. It doesn't actually go to 702. And so I'm making a finding that number 2 has been met. I'm going to jump to let me go to number 3. I think number 3 is the one that we're sort of arguing about. The testimony is the product of reliable principles and methods. Certainly, Mr. Cruz is making an argument that the state acknowledged that certain of her testing has never been accepted, or admitted, I should say, not accepted, admitted in a court proceeding. And that the reason that number 3 has not been met is because of that. And certainly there is, that is an interesting argument, and it's important to consider. The trial court does, however, have the power to, I shouldn't say the power, the authority
Oh no,
The
you meant.
discretion.
Oh no, you meant power. You said power and you meant it. And here's the finger wag. Here comes the finger wag.
That is an interesting argument, and it's important to consider.
It's never been admitted
The trial
before.
court does, however, have the power to, I shouldn't say the power, the authority, the discretion, that's the better word, the discretion to use, and we've heard this phrase many times today, the totality of the circumstances in making a decision as to whether any of these factors have been met. And the totality of the circumstances is that this witness is relying upon principles and methods that have been in existence for a very long period of time, that they have been peer reviewed. But I think most importantly for this moment is that it's just acknowledged, and the testimony has been that these results are presumptive. And I think that lends a different lens to this particular case. And so I'm making a finding that number 3 has been met based upon the testimony that of this witness.
Give me some adjectives in the chat to describe the lens of this particular case. What lens are we looking through here? What lens exactly are we looking through here?
That her testimony about her results is in fact presumptive. And I think that that nuance is crucial to this determination. And number 4, she has explained that she has reliably applied those principles and methods, whether they are accepted or have been accepted in a court of law or not. She has applied those principles and methods to the facts of the case. And so the factors are making a finding.
Whether they're acceptable in American courts of law is not really my concern here. As long as this witness says that she did these things, and then we're just going to, we're going to allow it. We're going to allow it. Why not? There's got to be a first time for everything, right? Science is not nuanced. Thank you. Ma'am, Honorable Judge Lott, if you are going to set precedent, if you are going to set precedent in a United States courtroom, you better have your I's dotted and your T's crossed, and you better have some case law to back it up. It can't just be a nuanced general feeling about why you think maybe in this cold case from 25 years ago, this black man should go to jail without ever, or to go to prison without what are we doing here?
Are accepted or have been accepted is crucial to this determination. And number 4, she has explained that she has reliably applied those principles and methods, whether they are accepted or have been accepted in a court of law or not. She has applied those principles and methods to the facts of the case. And so the factors I'm making a finding in 702 have been met. Most of the argument that the defense has made goes to the weight of her testimony, certainly the issue of the weight of her testimony, the credibility of her data, of her testimony, of her analysis is certainly open for examination. And I'm not making a finding on those particular things. I will say also that another reason why the court is finding that factor number 3 has been met under 702 is because the thought just went out of my brain. Hold on just a minute. Let me think of what I was going to say. It's been a long day. I need to come up with this. Hang on a minute.
Yeah, come up with it. You need to come up with it because it's never been done before. Come up with it. I'm on 1.5 speed, by
I don't
the way.
remember what I was going to say. So I'm just going to scratch that from the record. Anyway, I'm making a finding under 702 that the factors have been met by the state. The burden has been shown, and I'm going to deny the motion to.
Something funny, Judge Lott? Is something funny?
I don't remember what I was going to say. So I'm just going to scratch that from the record. Anyway, I'm making a finding under 702 that the factors have been met by the state. The burden has been shown, and I'm going to deny the motion to exclude the testimony of this particular witness, Ms. Lycon. And that'll be my findings. And I hope I remember what I was going to say. I'm going to try again. So, all right. We are going to meet here tomorrow at 8:30, and we're going to go over Mr. Peterson's.
Do you remember what they told you to say? Is this real life? Is this that was from last night? That was her ruling at about 6:30 in the evening, in which she decided that this expert, and I use the term loosely, testimony that we heard earlier in the day today was going to be allowed, and it was, and for the first time ever in any U.S. As such America courtroom, first time ever. Our cupcake is in the courtroom. She's been typing up her notes, I think. She's got a lot to say. She's got a lot to say, and we're here for it. Back to the chat. Thanks, Bethany. Now, it's lunch. Any word from our cupcake at the courthouse as far as the jury and what their demeanor is? No, I'm waiting to hear back from her, so we will get her thoughts as soon as we have them available to us. And long crime is still, well, she said 1 o'clock. All right, so we have a little bit of time. That was so what just happened is from earlier today. I mean, from earlier yesterday. That was her ruling because we didn't finish watching the Daubert hearing yesterday. And so where's Bob Alessi when you need him? This is a good time for Alessi and Yannetti to start their podcast, because this is something that I would love to hear from Bob Alessi on. The methodology of the hair analysis and the methodology of this testing that we heard about this morning with regard to, it wasn't the hairs, it was the saliva and the vaginal epithelial cells. Lugol iodine testing. First time ever that the Lugol iodine test has ever been admitted in court, and you were here to witness it. What do you think? My out has been raged. Oh, please. Thank you, Sherilyn, for your cash app. Says learned that the two prosecutors are shady. All right, well, that's interesting. Let me just go recharge and fill up my iced coffee while you guys hydrate maybe for a few moments. Let me see if I can give me some of your thoughts while we're waiting. Oh, Emily said that Jessica Berryman was posting about the judge being biased. Oh, is that why she called her out in court? You sent me a screenshot. Let's see what we have here. And then I guess maybe somebody must have sent it to Mr. Manchili. Hold on, let's see. Here it is. Was this from like today? Here's what it says. Oops. Well, this is from February 3rd. Request a new judge. There's the bias. And then she has a little Superior Court bio of the judge that says Lisa Lott was born in Columbus, Ohio, and spent her childhood in East and West Coasts. Bachelor's, University of California at Berkeley. Got her JD from Emory Law School in 1994. Began her legal career as a staff attorney at the Council of Juvenile Court Judges, an organization of dedicated public servants that helped guide her future legal choices. After the council, she became a prosecutor at the Gwinnett County District Attorney's Office. She then joined the Georgia Indigent Defense Council as their staff attorney and lobbyist. She subsequently entered private practice in Atlanta, practicing family law. Lisa Lott moved to Athens in 2000 when she was hired to be the senior public defender for juvenile court at the former University of Georgia Legal Aid and Defender Clinic, an organization which is now referred to as the Western Judicial Circuit Public Defender Office. Lisa Lott eventually became the chief assistant for the Public Defender Office and has been working at this office for the past 18 years. Well, I don't know how that circled portion shows bias. She was a public defender. Hold on. Am I missing something? And then there's another screenshot, I guess, from what was then 4 minutes ago that said, somebody said, Jessica Berryman, was the judge looking for you, or I heard wrong? She heard you've been talking junk about her. I'm watching now, OMG. And then Jessica said she definitely said my name. She called you out, gone up there until I got to, that's crazy. The eyes are looking, the eyes. Oh my God, another Handmaid's Tale reference. The eyes are watching. What are we doing here? When are we going to hear about any evidence connecting Edrick Faust to this case? Anyone? Anyone? Charlie said she can't find the words to justify this. Thanks, Charlie, for tuning in from down under. Free super chat. Marty says, thanks for covering this trial. There's been the usual chatter about why Mel isn't covering the boring ass Karen Reed civil updates, etc. This is by far more important. Really? They're chattering about who? The people who have nothing else to chatter about, or chattering about me not covering one boring ass Karen Reed hearing? There's other people who need help out there, and Edrick Faust is one of them, in my opinion. And I wouldn't read anything into the fact that I would not interrupt my daily live streaming of this particular trial to cover a hearing that can easily be covered on replay. I wasn't aware of the chatter, but thanks, Marty, for your 10. Shelquin says, listen to the land of lies. Mike Chappell, ex-cop of Gwinnett, Georgia, was framed by his own department and boss, been in jail for 30 years, maybe more corrupt than Karen Reed. Wow. I don't know if I have time to do that, but I will put it on my list of things to do. Thank you so much for your super chat. Joe Marr pointing out that there is not one piece of evidence linking this defendant to this crime. I Live for Now says, so dumb. This is so much more important. Listen, if I was here for clicks and likes and views, you know what I would be covering right now? Tell me, what would I be covering right now if I wanted 1 million views and 1 million new subscribers? I would be covering Savannah Guthrie's mother, because that's what everyone seems to want to watch, except for you guys who are wicked smart that are interested in the injustices going on in our country. So thank you for pointing that out. Grizz Girl says, I'm a little behind. The saliva swabs didn't match. Of course they didn't. This is so sick. Well, did she testify about any matches at all? She testified that one of the oral swabs was actually a vaginal swab. Did I just totally zone out during that testimony? Did I totally zone out? Because, I mean, I'd have to go all the way back to openings to try and remember how they're trying to connect. I mean, did they say that his DNA? Can somebody point me in the direction of the Commonwealth, the state of Georgia's theory of their case? That either his saliva was found in her mouth or his saliva was found in her privates? But we're not really sure because all the swabs were mislabeled. There was not a hair of his. There was no evidence that he was in the home. There was no fingerprints. The backdoor screen is the back screen is missing. And here's something. Well, let me see something right here. Oh, please. Here's an email that will remain anonymous from a person who was actually living in Athens at the time, was a law student at University of Georgia at the time when this actually happened, and says the following. All of the rumors or information led us to believe that the attacker was someone that Tara knew. Faust was never brought up, and the African-American man in an orange hoodie wasn't something I remember at all. The only male sighting we heard about was a mysterious white male running in jeans and a white shirt in the neighborhood that morning. Who runs in jeans? When we got word that an arrest had been made, all of my friends from law school, were shocked too. But in the last year, I have heard locals, non-students, say that in the 90s, listen up, the Faust family was the go-to for cops when a crime happened. Not murder, but robbery, drugs, assault, etc. Apparently, Edrick's father and other relatives had a long rap sheet and were in and out of jail. This made me think, if the Coleman-Baker Act, coupled with the attention the cops got from solving the Lake and Riley murder in February of 2024, gave them the idea to just pin it on the guy, Faust was the guy they went to. The current cops enjoyed the TV attention during Lakin's case. This is statements of people I know who were students in 2004. So, of course, this is rumor, conjecture, and innuendo, but knowing the cops were very, very familiar with the Fausts makes me really, really wary of his DNA match. She goes on to say, so of course, she says Athens was very segregated when she was murdered. Have you guys smashed the like button? She says, I felt like Karen Williams, the woman with the oxygen tank, was uncomfortable listening to her old interview because it was so apparent how she felt about African Americans then. I agree. Totally agree with that. I promise you, if the defendant was white, the tiptoeing around whether or not Tara could have had consensual intercourse with him would be vastly different. Athens is still a white man's town, but it has progressed since then. The apartments off campus are mixed races now, and you do see people of color or POC undergrad students with their white friends, but that isn't a sign of Athens progressing as much as the towns from which the students are coming to UGA. This trial gives me To Kill a Mockingbird vibes in the worst way. I worry about the jury. I do too. I guess we're going to see what happens. Also, she says, he says, Cruz primarily practices in the Atlanta area, which is 45 minutes to an hour away from Athens, but is an entirely different city. He's used to Cobb County, DeKalb County, and Fulton County courts. Those are huge counties and court systems compared to Athens Clark, which is one of the smallest counties in the circuit. Population is misleading because most of it is tied to the university. Judges wear robes and clerks swear witnesses in Atlanta. So there you go. Hello, Zoe. Here's how evidence comes across. Here's how this comes across, she says. State mishandled evidence labeling early on. State couldn't make a case because evidence wasn't labeled correctly. They spend money on private lab to fix evidence mix-up. Yep. That's right. Hates me. Hates me says, after Karen Reed, I was burnt out on trials. This is basically the first one I've been interested in. I agree. I agree. Thank you so much. It is. It's like kindergarten court. 100%. It's like kindergarten court. Yeah, I'm going to go get my coffee. I want to give you guys something to watch. Well, you know what? We're just going to put up the long crime feed until they come back. Let me go fill up my coffee. All right. Hold, please. Let's put this up, and court is on a break, so I'll be right back. This is the screen that we need instead of that. And today we have, remember we used to get to look at a fan. We used to at least get to look at a fan. This is just, what are we doing? Except now they're going to come right back. I'll be listening. Don't worry. Well, it looks like the light's gotten a little brighter since I left. Only in the courtroom, not in the actual place that this is happening. Well, it looks like the light's gotten a little Oops. Well, I can turn that down now. Okay. Here's the notes from our court watcher, Christy. Total of 15 jurors, she says. 1 black male, 3 black females, 8 white males, and 3 white females. I guess it's hard to tell who's the alternates and who are the official jurors, but we know that the seated jury is 8 men and 4 women, but I guess they're all sitting together. All in all, she says, fairly young jury, 1 older white male, probably in mid to late 60s. There are lots of note takers. Let's pause this for 1 moment. Pretty attentive, and they appear to pay more attention to Cruz. The older juror doesn't look up often, but is writing notes constantly. The jurors seem irritated with the judge in her rulings, as well as asking them to step out of the room so often. So it seems that they're irritated with the judge for that, perhaps. And this is, again, this is just her observations, Chrissy's observation. Or we're just going to call her anonymous right now because we don't want the judge calling her out. Attorney Cruz appreciated the remarks, and she told him that we are all rooting for him in his efforts, which is very nice. Happy to hear that. She's starting back up. Let's see what happens next. It's like you never know what you're going to get. It's like a box of chocolates over here. I just said what the racial makeup of the jurors were. Mitchell, were you not paying attention? 1 black male, 3 black females. So 4 African Americans, 11 whites. There's 15 altogether. Am I allowed to say whites? Is that racist? I don't know. All right, please don't write things that YouTube might not like in the chat. If you could try and refrain from that. You know what they are. You know what the things are. This is not the first day. It's not day 1 in YouTube. Or maybe for some of you it is. I don't know. Right. Why is an honest prosecution so concerned about the internet? Great question, little cupcake. I'd love to know.
Well, I want to do some things outside the presence of the jury, so you can get your witness in. Okay. Yeah.
I don't know if 1:30. I don't know if they're ending at 1:30 today. I thought they said 2:30. Martin, I don't know if you're an attorney or not, but you can find, if you want to reach out to Mr. Cruz, you can find his website and send him an email through there, but I can't keep stopping the stream to put up your comments. So if you want him to see them, that's what I would suggest that you would do if you are an attorney.
Record. All right. So there was some discussion at the bench about Mr. Cruz wanting to use a document to examine this witness under 24-6-613. The state asked, pursuant to that statute, certainly, to get a copy of what you were using. And then the state made an argument pursuant to 603. To 403. And so because of the state's argument about 403, the balancing test, I wanted to go through this moment outside the presence of the jury before I make a ruling. And so, Mr. Cruz, I'm going to let you examine this witness with that moment. And the law requires that you allow the witness to, I'll just use this language of the statute. The witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or the interest of justice otherwise requires. So before I get to that portion of the statute, I want to hear what we're talking about because the state has made a 403 objection. So you may proceed, Mr. Cruz. With the question you were going to ask him. He answered a question and you wanted to attempt to impeach him with a prior inconsistent statement. The state objected based on 403 grounds, and so that's why I'm conducting this hearing outside the presence of the jury.
Excellent. So just to let you know the process that was taking place when the objection was lodged, I was about to mark this as defense exhibit, I believe, 32.
You asked me if I have a defense exhibit 30?
Oh, no, sir. I was asking.
Not yet.
Well, I'm sorry.
Not yet.
Okay. So I was going to mark this
Okay.
as defense exhibit
All right.
32.
Okay.
And my next question to him after I mark this as defense exhibit 32 was going to be in your March 19th, 2001.
Well, actually, before we even get to that, Mr. Cruz, we may not need to get to that moment. Let me ask you this question. Let me ask counsel. Now that you're going to mark it as an exhibit, it kind of takes a different turn.
That's where the objection came.
Okay. So, well, it did because you weren't tendering it, and you don't necessarily have to when you're dealing with a prior inconsistent statement.
I actually was going to admit the prior inconsistent statement into evidence,
Okay.
but I typically mark it for purposes of the record.
Okay, well, that's fine. Well, let me ask this question of the state first. Based on that he is going to offer it into evidence, do you have any objection? Do you have any objection to that? I mean, based on the conversation counsel had with the court at the bench, the reason I'm doing this outside the presence of the jury is because of the 403 argument. So is there any objection to the tendering of that document? Is there going to be?
He's in custody, Rhonda.
Is
Been
there
in
going
custody
to be
since
any objection to the
2024.
tendering of that document?
I think that there would be, as it relates to examination regarding a hair found in a wallet. And the reason is, Judge, and I would, if the court allows me under 24-1-104, I think this would be a matter of a preliminary question. And I can state in my place that pursuant to documents that are in discovery and produced to Mr. Cruz, this item actually didn't come into, the item was not believed to contain any hair at the time of the initial processing of the crime scene. It was returned to the Baker family, who then over 2 weeks later, on February 8th of 2001, brought the wallet back to Athens Clarke County Police Department and relinquished custody to the Athens Clarke County Police Department. And then subsequently, in a transcript of an interview between ACCPD and the Baker family in May, Miss Baker's father, Mr.
I'm hearing a dinging in the courtroom. Does anybody else hear it, or are my ears just super sensitive? What? So you gave the Baker family the wallet for 2 weeks, and then you took it back, and then there was a hair on it, and then you tested the hair? And now I need to know more about this hair. And now he wants to argue chain of custody over his own evidence. Right. Shield and sword. Shield and sword. If there is, this is like the 3-card Monty prosecution. That's exactly what this is. I'm going to take that back because it strains credulity. It sure does. If you thought it might strain credulity, it absolutely does.
Actually didn't come into 104. I think this would be a matter of a preliminary question. And I can state in my place that pursuant to documents that are in discovery and produced to Mr. Cruz, this item actually didn't come into, the item was not believed to contain any hair at the time of the initial processing of the crime scene. It was returned to the Baker family, who then over 2 weeks later, on February 8th of 2001, brought the wallet back to Athens Clarke County Police Department and relinquished custody to the Athens Clarke County Police Department. And then subsequently, in a transcript of an interview between ACCPD and the Baker family in May, Miss Baker's father, Mr. Lindsay Baker, stepfather, but the person she considered to be her father, Mr. Lindsay Baker, indicated to police that we found a hair in that wallet. What have y'all done with it? And so I imagine what
If that hair belonged to Edrick Faust, you can bet your ass he wouldn't be arguing right now. You can bet your ass he wouldn't be.
Mr. Cruz is going to question the witness about is whether or not that hair was tested. And so I guess our objection under 403, or it would, our objection pursuant to 24-1-104 is there's been a lot of discussion about chain of custody as it relates. Now, in this particular case, circumstance, I think there is a legitimate concern about chain of custody and the manner in which it came into the possession of law enforcement and GBI, which is why additional testing was not done. If testing had been done, it still probably wouldn't be admissible in a legal proceeding.
Don't kid yourself. Everything is admissible in lethal lots courtroom. It's all admissible. Nothing's precluded here except if the defense wants it in. They got to redact names of other suspects. But now you're saying, oh, even if we did test it, it wouldn't even be admissible. Oh, are you joking, sir?
Is a legitimate concern about chain of custody as it relates. Now, in this particular case, circumstance, I think there is a legitimate concern about
now there's a
chain
concern
of custody,
suddenly,
and the manner in which it came
suddenly
into possession of law enforcement and GBI, which is why additional testing was not done. If testing had been done, it still probably wouldn't be admissible in a legal proceeding due to the fact that it came from a wallet that had left the crime scene and been in the possession of other parties for, you know, fairly extended period of time. We're not talking about an hour or something like that. So.
Okay. All right, thank you. Mr. Cruz, do you want to respond to that? And then I'll let you ask the question. I may have some questions for you. Do you want to respond to that?
I just want to make sure I understand the objection was to 403, but also chain of custody. Am I understanding that correctly?
Well, I'm not going to put words in Mr. Yellman-Shilley's mouth. I can tell you what the court thinks it is, but go ahead.
Foundation for admissibility of the evidence that he is questioning the witness about. I think if we are going to talk about evidence, it needs to be present and tendered in the courtroom. Now, it could be that Mr. Cruz goes through the process of tendering that evidence in some manner. It just hasn't been done yet. So, I mean, I guess my objection's on a couple of different grounds.
All right.
Yeah.
Go ahead.
So I understand foundation
Let Cruz speak. We need shirts. Let Cruz speak.
is a ground, chain of custody is a ground, and 403 is a ground. If I could ask clarification from the Honorable Court or Mr. Yellman-Shilley, as far as 403, what particular ground do I need to address?
You can ask the state.
Well, Your Honor, when we were at the bench, I think my original objection was actually to the predicate requirements of a prior inconsistent statement not having been met, because I think Mr. Peterson testified that he believed that it had come from a purse, and Mr. Cruz had indicated it had come from a wallet, and we stated at the bench, so it was our belief and our understanding of the evidence, it actually came from a wallet that was inside of a purse, so it wasn't necessarily something inconsistent with Mr. Peterson's testimony.
All right, so in regards to...
If you know you're charging this defendant with burglary, right? Maybe he went in her wallet to try and steal some money. So maybe his prints would be on the wallet. Maybe there'd be something else on the wallet, but you don't want the wallet in at all, right?
The foundation of a prior inconsistent statement. Mr. Peterson, I asked him, was it a pubic hair? He said it was a head hair. I asked him, was it on a wallet? He said it was in a purse. It's semantics, but my particular question asked about a wallet. His report references a wallet. It's not reference a purse. So the foundation has been laid for a prior inconsistent statement. He was confronted with the statement. Well, was about to mark the exhibit to confront him with the statement before the objection came about. But once I've given him an opportunity to, or once I've confronted him with that statement, if he says, no, it's still a head hair, or no, it was in a purse, at that time, I would tender this into evidence as impeachment material. In regards to the chain of custody, this isn't a chain of custody issue. Chain of custody applies to fungible evidence, not to documents. So chain of custody would not apply in this situation. In regards to the state's argument, as far as I need to tender the hair in order to impeach Dr. Peterson, in regards to the hair, there is no case, no law that exists that would support that proposition anywhere, probably in the United States. And lastly, in regards to 403, Your Honor, I still wasn't 100% clear on the exact ground of 403. So I would ask for the 403, just look, the specific grounds for 403.
Confusion of the issues and misleading the jury.
Okay. In regards to confusion of the issues in this case are whether or not Mr. Faust committed this crime. This evidence is evidence either in support of Mr. Faust committing the crime or evidence that goes against Mr. Faust committing the crime. The anticipated testimony from Mr. Peterson's report is that the hair that was on the wallet was a pubic hair, and it was of Caucasian origin, or the way I asked the question, it was not a African-American hair. I had no intentions to ask about testing the hair. I now do, but it's relevant. It won't confuse the issue because it goes directly in line with our theory that Mr. Faust was never in Ms. Baker's home. And this testimony supports that materially, Your Honor.
Mr. Cruz, let me ask you this question. Well, first, I'm going to let you ask him about a prior inconsistent statement and give him the chance to respond. And then I want to talk to counsel about something else.
Sure.
So you may go, because I don't agree that you've established that you have the right to present evidence about a prior inconsistent statement yet. So if you believe that's going to be the case, I'm going to let you try that.
Sure. May I mark the exhibits, Your Honor?
You can for this particular purpose, but we're having a hearing outside the presence of the jury.
Sure.
So just go ahead and ask him the questions you were going to.
Yes, ma'am. Thank you for your patience, Mr. Peterson. You obviously know where I'm going with this line of questioning, but you examined the hair found on Ms. Baker's wallet. Is that correct?
Yes, I had earlier said purse, just from my recollection, but by looking at the report, it does reflect hair from a wallet.
Okay.
Yes, Helen, because the witness has been there listening to this the entire time. Yes. So now he knows what to say. The hypocrisy of the DA is astounding, says Empty Evidence Bag. You've changed your name, and I noticed because I see your cute profile pic. This judge threw the scales of justice out the window, says Texas Dave Matthews Band fan. I think that's what it is anyway, right? DMB fan? I hope so. Do I have any jewelry on today? I think I do. This is, yes, Martin, the witness, every single time there's a discussion like this, the witness has been on the stand. He doesn't leave the room. I don't get it. He's not directed to go in the hall.
Okay. And would you agree that it's also a pubic hair?
No.
No, it's not
Mr.
a
Peterson,
hair.
in your report dated March 19th, 2001.
I'll take that back one sentence.
Just from my recollection, but by looking at the report, it does reflect hair from a wallet.
Okay. And would you agree that it's also a pubic hair?
No.
Okay. Mr. Peterson, in your report dated March 19th, 2001, did you state, course indulgence, I'm mistaken. You are correct. You are correct. Okay.
All right.
So we are clear on the wallet portion, and I was incorrect as far as the pubic hair. Please forgive me.
All right, thank you.
It's not a pubic hair.
Let me just respond then to, well,
Nobody rubbed their pubes
Before I
on the
respond.
wallet. I was a little confused.
unless Mr. Yalamanchili, since it's your motion, do you have anything else you want to say about your argument about this information under 403?
No, Judge.
Okay. Mr. Cruz, do you want to respond to their argument about this evidence being violative of 403?
The proffer that I gave to the number court, I would stand by that.
Okay. All right. Thank you. So both parties have given a proffer about what this line of questioning is about. And I will say this, I agree with the state that this is violative of 403.
Shocking.
Yes, ma'am.
Because of the proffer that the state has made about the circumstances surrounding the testing of this purse wallet several weeks later, under the circumstances that they have described, is a moment, I would say, of profound confusion, possibilities for the jury. And so I'm going to grant the state's motion with regard to the concern about 403, and I'm going to instruct you not to go into that area of questioning with regard to the testing of this purse, wallet, this line of questioning. I'm going to instruct you not to go down that line of questioning.
But don't touch on the wallet to make sure.
That's correct.
Yes, ma'am.
All right, thank you. All right, I'm going to bring the jury in because I want everybody to be mindful. It is 1:20 and we are supposed to be ending at 2:30 today. As best we can, there's a juror that's going out of town. This may be our last witness, but I just want everybody to remember, we're running behind. It's 1:20.
Awesome.
So,
Funny
all right,
judge.
anything else?
Georgia Rule of Evidence 403 allows a judge to exclude relevant evidence if its probative value outweighs the prejudice, outweighs the danger of unfair prejudice and confusing the issues and wasting time. Awesome. Awesome. Our court watcher, thank you so much, Christy. We love you with all of our hearts, says this. There are certain things that I'm not going to read to you because I don't want these people outed. She said that there's no fund or anything for Mr. Faust as far as she knows. She says there were no protesters or supporters outside the courthouse when she left. And there's apparently, they have to be 1,500 feet away. So apparently there's some sort of buffer zone there. She says that the jury box is to the right of the prosecution. So when we see the witnesses that we are looking at, looking to the left, to what looks like their left, she means that that is the jury box that they're looking at. And there's only a railing between them, so it's very close. Maybe it's even like similar to how small the Karen Reed, the distance between the Karen Reed jury box was from the witness box. I don't know if any of you remember that, but it was very, very tight. She says the cameraman is with Dateline, the only camera I saw. That's not unusual because usually there's a pool camera who's required to share that with all of the other. I don't know what just happened with this split screen, but that's probably going to make me freeze again. If it does, let me know. Hold on. Let me get rid of that. Say goodbye to that. Okay. And also, she says the courtroom is pretty big, much like the Adelson courtroom, but with more seating, that there's 10 pews. We call them pews because they are more like church pews than regular seating. 10 pews deep behind both the defense and 10 pews deep behind the state. And in this courtroom, as you can see, the state and the defense tables are kind of side by side, unlike in Massachusetts, where most of the time they're one behind the other, and it's the prosecutor's bench that's attached to the judge's bench. Somebody told her that Detective Bigham is the blonde lady sitting directly behind the DA, kind of like at the bench with the prosecution, sort of. She says the gallery wasn't full on either side, but there were definitely more people on the defense side. And then she said she was the only white person on the defense side, and she got a few side eye rolls, a few side eyes from the white folks on the state side. And she says, I loved it, and I wouldn't look away from them until they stopped staring at me. I just kind of showed them my best resting biatch face. And I was like, yes, queen. She said one of the ladies with the cameraman, she's been there all week. And she told me she's been able to hear the jury. Well, I don't want to repeat that. Laughing, maybe. They're having a good time, basically. They're having a good time back there. Jury room is not far at all. It's right off the courtroom. And any other questions? Any other questions for her before she takes off because she has to go for the day? And there were at least 2 or 3 other viewers who emailed me to say that you were going to try and get there this week. If you guys are going to be there on the same day, hopefully you can connect. And if you are going to be there on a certain day and someone else is going to be there on a certain day and you want me to introduce you through email or whatever so you guys can connect, I would love it. I love it when the cupcakes get together outside of court. And that happened during the Brian Walsh trial, I think, right? Emily C. went to court the same day that Kim Yellow Ledbetter was in court, and they got to sit together and meet. And I think Emily C., that was her first day in the courtroom, and she was very excited to have someone to sit with. So there's that. Well, I told you the makeup of the jury earlier, but if you weren't here, we know that the main jury consists of 8 men and 4 women. They are all sitting together, so we do not know who the alternates are, but based on the 15 that are sitting there, there are 4 black American, 4 black, 4, can I say black and white? Is that acceptable? 4 blacks, 1 male and 3 female blacks. As far as whites, 8 white males, 3 white females. And all of them are fairly young. The oldest is like a white male in his mid to late 60s, and he's a big note taker. All right. So if you missed it, there it is. And we love you, Christy, doing the Lord's work. And thank you so much. And if anybody else is going to get a chance to get there, let me know so that hopefully I can connect you guys, because you guys are out there doing the Lord's work. All right. Young jury is the best. I agree. All right. Here we go. I can't keep track. Does she send them out again? Or is she bringing them in again?
They're supposed to be ending at 2:30 today. As best we can, there's a juror that's going out of town. This may be our last witness, but I just want everybody to remember, we're running behind.
I guess she's bringing him back. She doesn't suck her teeth. It's like she's smacking her lips, and I don't know what the hell. Everyone's saying thank you, Christy. So if you're listening on your way home, thank you so much. We love you. We love you. And here's Mr. Faust. Here is Mr. Faust standing accused of murder and a whole bunch of other things like rape, sodomy, burglary, a couple of different kinds of murder, malice murder, this murder, that, any murder they can throw in. My understanding is he's been in custody since his arrest in 2024. And based on the email that I read you earlier, seems that the Faust family has been the fall guy for this county for maybe decades, including his dad. Because when you look up Edrick Faust, and I think his dad also might be named Edrick, there's a lot of entries. Somebody told me a story about how they got his DNA, but I'm not quite sure if that is, oops. If I can't really confirm it yet, so I want to see if we can ever confirm that, and then we will talk about that. Okay. She did tell me also earlier, a part of the earlier conversation that we had is that they seemed kind of annoyed at the judge when they kept being asked to leave the room, and that they are more attentive to Mr. Cruz than the other side. And these are just her observations. Look, I don't know, they're her observations. And that is what we need to know and see and hear about. Here we go.
Thank you. You all may be
Prayers
seated.
up for Edrick Faust. Wanting to get his
Cruz,
mug
your
shot in
witness.
from 2 weeks after this murder for something completely different and unrelated.
Mr. Peterson, you would agree that there was pubic hair found in Miss Baker's left hand?
Correct.
And that pubic hair was tested against.
Wait. There's pubic hair in her left hand? Okay. I love you with all of my heart, Christy. Okay. We're going there.
Mr. Peterson, you would agree that there was pubic hair found in Miss Baker's left hand?
Correct.
And that pubic hair was tested against the known sample of Mr. Melton's head hair. Is that correct?
No, that would only be compared against pubic hair.
So it's compared against Mr. Melton's pubic hair?
Yes. I believe that's correct.
All right, in your report,
He's allowed to keep his report up there and keep referring to it. Okay, I see how we do things.
in your report, did you write microscopical examination and comparison of the question hair removed from items? Let me ask you this before I even answer that sentence. Item 10, we can agree, is the hair from Ms. Baker's left hand.
That's correct.
Okay. And in your report, you wrote microscopical examination and comparison of the question hair removed from item 10 with the known head hair of item 21, 22, and 23 reveals they have dissimilar microscopic characteristics and therefore could not have originated from the same source. Is that fair?
Yes.
Okay. And item 21 is listed as the head hair of Chris Melton. Is that correct?
Correct.
Okay. And I believe on director testimony was that hairs that grow in different areas have different characteristics. Is that correct?
Yes.
Okay. Can you show me the report where you tested item number 10 against Chris Melton's pubic hair?
Don't believe that's in the February 2nd report. I think that's in a subsequent report.
Sure. Can you show me?
I wish you would show me.
Sure.
Okay, all right.
And was seeing all of your reports refresh your recollection?
Well, I have two reports, States Exhibits 136 and 137.
Well, Mr. Peterson, you just asked me you wish that I would show you. I'm willing to show you. Would reviewing your reports refresh your recollection?
Yes.
Okay.
Do 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 do. It's like the tournament of champions in Jeopardy. Do 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 do.
I am
Do,
2001.
do.
Or let the record reflect that I'm showing you your report from March 19th, 2001, May 16th, 2001, October 11th, 2001, February 2nd, 2001, February 27th, 2001, and that's two reports, two separate reports, and March 19th, 2001. If you'll take a look at these documents to refresh your recollection and let us know once your recollection is refreshed. May I approach? And just so there isn't any confusion, to make the record clear, I am asking about the pubic hair found in her left hand being tested against Mr. Melton's pubic hair.
Well, if that hair from the hand, which was eliminated microscopically, the victim's own hair, if there had been another pubic hair sample submitted, then it would have been identified as also being consistent.
What?
The answer to my question, excuse me, my question is, was the pubic hair found in Ms. Baker's left hand tested against Chris Melton's pubic hair?
Well, the characteristics of his hair are dissimilar than those of Tara Baker's hair.
Please.
Are you asking me that there's...
I'm sorry. I thought you said a pubic hair can only be tested against a pubic hair. Am I confused, or is he confused? Or is he trying to confuse us? Hold on.
Hair found in Ms. Baker's
also being consistent?
The answer to my question, excuse me, my question is, was the pubic hair found in Ms. Baker's left hand tested against Chris Melton's pubic hair?
Well, the characteristics of his hair are dissimilar than those of Tara Baker's hair.
Please.
Are you asking me that there should have been a recorded statement saying that the hair was eliminated, as opposed to my testimony today that it is not similar to Tara Baker's pubic hair and therefore could not have been his?
The question I'm asking is whether the pubic hair found in Ms. Baker's left hand was tested against Mr. Melton's pubic hair? That, and if you can, yes or no?
It was not similar to the pubic hair from her left hand.
Was it
That doesn't
tested?
answer
Eliminated.
my question is, and maybe I'm saying that wrong. Please forgive me. And if you can answer yes or no for
You're
me,
not.
please do so.
He is such a Southern gentleman, Mr. Cruz, and I cannot ever, disparage anyone for being a true Southern gentleman. He's very apologetic. He's very kind. He needs to learn how to be meaner. That is my advice to Mr. Cruz. Get mean. Show us your bulldog. Show us your bulldog. You need to outshark these sharks. You need to get out your sword and be a gladiator and you need to stop being so nice to these morons. They're trying to screw you every way possible. You're not phrasing that question wrong. He just doesn't want to answer it.
That doesn't answer
Eliminated.
my question is, and maybe I'm saying that wrong. Please forgive me. And if you can answer yes or no for me, please do so. You had Mr. Melton's pubic hair. Is that correct?
Yes.
Okay. And pubic hair was found in Miss Baker's left hand. Is that correct?
Yes.
Okay. Was that pubic hair of Mr. Melton's ever tested to see if it was the pubic hair in Miss Baker's left hand?
It was indirectly eliminated because a comparison of the knowns also took place to know what their characteristics are, and they were not found to be similar, so it could not have been consistent with the hair from the left hand.
Is that a no?
Sorry.
Is that a no? Is
No,
the
it's
answer to
not
my
no.
question a no?
The comparison does not have to be a direct comparison. The characteristics of the two known samples are not the same, so they both can't be consistent with the hair that's only consistent with hers from the left hand.
And I thank you for the information. That is great information, but I'm asking you a specific question. To my question, is that a yes or a no? Was it tested?
Yes.
Can you show us the report?
No.
No more questions, Your Honor.
Any redirect?
It was tested, but you can't show us the report because it wasn't tested. It was indirectly tested because I thought about testing it, but I didn't test it. That was great. Well done. Scored some points. You're right. He's already been held in contempt by this judge and forced to pay $1,000 fine that he needed to have in his hand at 9 a.m. the next day when he showed up. But the pubic hair found in Tara Baker's left hand was not compared with the pubic hair of Chris Melton when they had an exemplar pubic hair from Chris Melton to test it with. Let's hear that again one more time.
And I thank you for the information. That is great information.
From the same, so they both had with the hair from the left hand, and they were not found to be similar. It was indirectly eliminated because a comparison of the knowns also took place to know what their characteristics are, and they were not found to be similar, so it could not have been consistent with the hair from the left hand.
Is that a no?
Sorry.
Is that a no? Is
No,
the
it's
answer to
not
my
no.
question a no?
The comparison does not have to be a direct comparison. The characteristics of the two known samples are not the same, so they both can't be consistent with the hair that's only consistent with hers from the left hand.
And I thank you for the information. That is great information, but I'm asking you a specific question. To my question, is that a yes or a no? Was it tested?
Yes.
Can you show us the report?
No.
No more questions, Your Honor.
Any redirect?
No.
Mr. Alderman Chile.
No, Judge.
All right. May this witness be excused?
Yes, we ask that he is.
Any objection from the defense? You are free to go, sir. You may call your next witness.
Oh,
You have an hour.
he's going to approach the bench again. And he's shaking his head like, we're going to need more than an hour. Yeah, I don't know, Judge, if we can, start now. I don't know if we could start now. Mm.
All right, ladies and gentlemen, believe it or not, we have finished early today.
Oh, could you imagine if the defense
So-
asked to finish early today? She said she was going to keep them until 2:30. Until 2:30. It's now 1:45. Wow. Could you imagine if the defense asked if they could stop early because their witness wasn't ready or whatever?
particularly the person going out of town. Yay. All right. So I'm going to
Yay!
release all of you today, obviously at 1:30, and ask you to return again on Monday at 9 o'clock. Obviously, in the meantime, my instructions continue to apply. Please don't discuss the case with anyone. Don't do any independent research. Don't look on social media with regard to this case if it is on there, or the news if it is on there. All the things that we've discussed.
Do you think the first thing that they're going to do when they get home is Google Jessica Berryman? Because you called her out in open court wanting to know if she was in the courtroom after your huge hocus pocus secret powwow. Something that we need to bring to the attention of the judge right away. I don't remember if the jury was in the room. I don't think they were.
Does anybody have any questions for the court? Don't go to any locations that have been discussed, of course, by any testimony. Anybody have any questions for the court before I release all of you? I appreciate your patience this week. It has been a productive week in terms of a lot of things we've gotten through. I appreciate your patience. I know you go in and out of the jury room a lot. That's certainly common in a trial, but I know that it is sometimes, it could be aggravating for you to get up and get down and get up and get down. I know that. So I appreciate your patience with that. Next week, we're going to hopefully have more of an opportunity to have a normal lunch break. Like I said earlier, you can go outside and stretch your legs and things of that nature. We'll have to see how the timing goes, but that would be my plan. So with the thanks of the court, you're all free to go, and we'll see you Monday morning, 9 o'clock. Thank you. In this courtroom.
I don't know if they have things to discuss with the judge or if they're going to cut the feed. And they have cut the feed. And so that's it. We're coming back on Monday. We're coming back on Monday, but we have to still recap. Wait, I think, unless they're coming back now. Hold on. Let me give it a second. We still have to recap most of day 3 when I was sick. So make sure you're subscribed. Make sure you have your notifications set so that if I'm able to do that over the weekend, even though it's the Super Bowl, I may be able to do a quick stream on that maybe tomorrow. If you are interested, I do have a playlist for the videos on this case, if that's what you're asking. All right, so that's done. So we're done. Tell me what we learned today, class, and what questions you still have, and what the F you actually think is going on here, and whether you're finding this trial interesting and think we should continue to cover it. Well, did you test it? Well, he says he indirectly tested it, but he wasn't really clear, and he couldn't show a report saying that he did. So it's just kind of like, trust me, bro. It just did. Ipsy Dixit. Ipsy Dixit. I would never, ever recommend making any complaints against any judges. So thank you, Gloria, for your super chat. But I cannot ever, in good faith, recommend that. The answer would be no. David says the state's theory is Chris Melton didn't do this, so Faust must be guilty. Right. Right. Nobody else could have done it, so he did it. Sounds familiar, right? It sounds like the Sarah Grace Parker case, which coincidentally, it's also in Georgia, right? Nobody else could have done it, so she must have done it. Thank you, David Reese. Charlie says the state may as well have picked up any rando black guy off the street. Thanks, Charlie, for tuning in from Down Under and for your 5. And also says, anyone see Gregory Peck in court? It is like To Kill a Mockingbird. And Tara is pinging the DA's mics at KBD. It is the spirit. There's an angel. Every time a bell rings, an angel gets her wings. And maybe that's Tara trying to tell us something. I don't know. Sarah, thanks for your 20. Says, I'm more triggered by this, by the young versus old jury for this 64 years young outraged person. LOL, love you with all of my heart. I don't know that that was meant to be disparaging in any way. I find it heartening, actually, that the jury is younger, because I think they're going to be less inclined to believe the BS. So I kind of like that. Thanks for your 20. I'm not sure what you really meant by that, but I don't. Age is just a number. Age is just a number. But in the case of in a case like this, I think a younger jury is better for the defendant. Because they are more likely to believe in, police corruption, law enforcement corruption, and all kinds of things as such like that. Hold on, I don't know what's going on over here with this other screen. It's a world of technological difficulties. Pubic hair in her left hand. We now know she was left-handed. Well, I don't know, do we? Thanks, Charlie. I mean, that hasn't come up yet. Let's go, girls. Became a new member. Welcome. Emily says, this judge triggers me. She's so much like Bev. Thank you very much for being here for 3 months. Laura says, so no, does it hurt to say? Yeah, sometimes, you know, experts don't like to admit that they're wrong or that they didn't do something right or that they didn't test the right thing. They don't like to admit it. Charlie says, this is the gosh darn 25-year-old murder trial and the judge is all smiles and giggles. Yeah, of course she is. Because, you know, it's just about the Coleman Baker Act and getting a conviction under it. We learned that anyone can be an expert today, right? It doesn't matter if this has ever been testified to in any court in the land ever before. Britt says, absolutely, this trial needs to be seen, and we want to hear about it and watch it. We need to get more people interested in this. We need to get more law tubers interested in this. We need to get maybe I can call Ed Wallace and see if he will start talking about the forensics or lack thereof or the testing and the problems with the testing in this case. Let me see what I can do about that. Venus Blue says the prosecutor's mad that he knows he's not being shown in a good light. Uh-huh. I think so. And we learned also, to moms says we learned that Massachusetts isn't the only place your constitutional rights go to die. It's so true. Sometimes we think we're alone. Just when you think you're alone. Think you're alone now. Hold on. What is this? Oh, thank you so much for this. Oh man, hold on. 1 second. Something very interesting here that Carrie sent me. The arrest starts on page 10. All right, hold please. Well, thank you for sending this to me. I'm going to download this and talk about it hopefully tomorrow when we go over day 3. But here's what it looks like she's sending me. Documents indicating that May 8th of 2024, it looks like the Georgia State Police were kind of following around Mr. Faust to try and get him on something, maybe, is what I'm gleaning from this, and to try and get a DNA sample during the traffic stop. And that's apparently what they did on May 8th of 2024. I don't know what these papers are that you're sending me. So before I talk about them in greater detail, it is a amended motion to suppress evidence obtained due to illegal search and seizure. And this was a defense motion that I'm sure was denied because it goes all the way back to October of 2025, which, you know, wow. Just when you thought it couldn't get any crazier, that's what I was trying to show you with receipts. And thank you to Carrie for providing me with the receipts. So there's that. Hopefully you guys can get some more people interested in this case. So I'm not the only one out here screaming into a void, but it wouldn't be the first time. Everybody's busy. They're covering other cases, but I feel like this one really, really, really knows, really needs the attention, but not everybody has the time to get so invested, especially since that it's already on day 5. So it's so hard for people to catch up on 5 days of trial, which is like 40 hours worth of content without my commentary, just going to watch it alone. And that is hard for people to do. So we'll try. We can't guarantee, but it's also hard to have somebody as a guest if they're not up to speed on everything. Not that I can say that I completely are up to speed on everything, but I am going to try and get up to speed on more. Yeah, Brian Enton is way too involved in Savannah Guthrie's mother's disappearance. I don't think that that's going to really happen ever. I mean, not right now. Anyway, and Dispatch Debbie says, I've learned that I will not live in Georgia either. Well, take a re-listen because I want to go re-listen to the expert testimony that we heard today to see what actually it showed, because it was really kind of nothing. What we learned was that the pubic hair found in Tara's left hand was not compared to Chris Melton's pubic hair, and they had his sample. And we also learned from the first witness. I've got hardly any notes from today. She didn't test the samples until October, of 2024. She did some Lugol iodine testing. One of the oral swabs was positive for saliva. But again, it's only presumptive testing for saliva. It's not confirmatory testing. That there was some presumptive testing done for vaginal epithelial cells, but that was negative. And then the cassette was thrown out. And then what are we doing? What are we doing? We learned that an expert who should not have been an expert testified regardless. And we learned that there's a whole lot of shenanigans going on in Athens, Clark County, Georgia. And I haven't heard one bit of evidence tying Edrick Faust to the crime with 5 days of full trial testimony. Who else can we reach out to, Melanie? I don't know what you mean, but if you have any law tubers that are that you like, that you want to cover the case, you could certainly reach out to them. But I mean, I can't promise that anybody else can get invested at this point. Thank you very much for your, Krista Ray, for your super chat. Charlie said until a 1967 SCOTUS decision, anti laws certainly prohibited marriage between African Americans. That may be true. So there was no interracial marriage, you're saying, until 1967. Thanks for your 20. I'm not really sure how that's applicable here, but there's a lot of things that there's some. We looked up the statute on whether sodomy was illegal, because in the prosecutor's opening statement, he made it a point of saying that Chris Melton and Tara Baker did not have backdoor sexy time ever. They would never, ever, ever do that. And I said, I wonder if it's still on the books in Georgia that it's against the law. Loving versus Virginia. Well, that's interesting, says Mastad. So thank you very much, Charlie, for your 20. And DK, thank you for being here for 27 months. If they want to make a conviction in this case, then go after the right person. I don't get what they're doing here. What they're doing, well, we've talked about it several times, but I think I know what they're doing here. And they have to justify the Coleman-Baker Act. And I think that is exactly what we are doing here. All right, I got to, I have some appointments that I need to get to this afternoon, so I'm going to have to jump. But thank you guys for being interested in this case. I appreciate you with all of my heart. And I thank you for spending so much of your days with me. I mentioned Ed Wallace. I think I'm going to try and see if he's not busy, but he also has a full-time job. So we will try and do that. And thanks to the moderators for keeping it classy in here. Thank you all for being here with me for so many hours this week, even though I have been less than up to snuff with my feelings, although my snark has come back a little bit. Go Patriots. Make sure your notifications are set. Make sure you share the stream out. Make sure you please comment after the stream is over. It helps the algorithm, and hit the like button and do all of those kind of things. And thanks for becoming a member, Blazy. I love you guys so much. Thank you for sharing the injustices of the world with me. And thank you for being interested in our little innocence project of YouTube. I thank you, Blazy. It's so much more interesting for me to cover acquittals than it is to cover guilty verdicts that we know we know how the film is going to end. And I am so much more interested in finding potential acquittals than I am guilty verdicts that we all know are going to happen. And so even though the audience is smaller for that, I don't care. Be cool, be kind, stay cool, stay kind, stay classy, tip your waiters, thank your moderators, and I will see you guys real soon. Peace out, my friends. I love you with all of my heart.